I am told that interlocutory applications, the department will not accept unless the plaint is filed along with. So not kindly give us leave to file it. Then thereafter it will come before your lordship on Monday for 12-way leave. So my lord, we want, subject to the 12-way being given, my lord, we'll move the interlocutory application. So I'm asking for your lordship leave to file the plaint along with the interlocutory application.
12A.
No, not now, not now. It will come before your lordship on Monday. So the lordship kindly gives us leave to file the interlocutory application because of the urgency along with the plaint.
Leave is granted.
Grateful, my lord.
Leave is granted to file the suit along with the interlocutory application.
My lord, may I have you?
Subject to acceptance by this court.
So may this get listed. We'll give your lordship's officer all the details so that it can get listed on Monday. Grateful.
If it is affirmed, then you may.
Yes, of course. We'll give your lordship the officers the.
My lord, may I have your lordship
details.
leave to mention, my lord, this is in relation to the election petition, my lord, in which your lordship was pleased to pass an order on 13th of August, my lord. Especially particularly in view of the returning candidates has already passed away. And there is a direction upon the plaintiff petitioner to file a cause publication under the Gazette in terms of section 116. My lord, I am an interested party over here. Now the difficulty is I intend to take out an application for impleadment. Now I cannot lay down on the hands whether the Gazette has been published on the in terms of the direction of your lordship, and I am not even aware of the cause title. I'm humbly seeking your lordship.
Why you not received the notice?
My lord, I have not.
When the writ of summons was served, you have not received. Who are you?
My lord, I am a party. I am a resident of that constituency. My lord,
Huh?
I am a resident of that constituency. It's in relation to the election petition, my lord.
Residence, how you are right? Whether you are contesting
My lord,
candidate or you are any of the officer of the.
My lord, section
election
116, my lord, I'll try to satisfy your lordship. Section 116 empowers me to contest the election petition. Section 116, if I may please rely
I'm
on
opposing his prayer, my lord. First of all, my lord, what happened was they tried to short circuit the procedure, my lord. Despite pendency of this particular writ application, some strangers, my lord, they gathered together, they moved an application under Article 226, my lord, praying for a direction upon the Election Commission of India for declaration of election. But we raised the objection that there is a pending election petition. Produce the orders, my lord. The matter, they were asking that please dismiss the order, so that they intended to go up to the Honorable Supreme Court, my lord. Now the matter is, my lord, still pending, my lord, for exchange of affidavits. Now, my lord, this is now the second attempt, my lord. Nothing but, my lord, meddlesome interloper, total stranger for prejudicing the proceedings. My lord, I am opposing the prayer, my lord. The order was passed on the 3rd of September 2025. There was enough time, my lord. There is no such urgency as my learned friend is trying to make out.
My lord, I am not contemplating any urgency, my lord. Why I am seeking this leave, my lord? I am only filing this application under
File the department.
short cause title because I am not versed. My lord, I am not aware. I am not privy to the. I am not privy to the area of the parties in the original petition, my lord. My lord, hence I am seeking leave. Once I am been provided with a copy of the original petition, my lord, then I can file.
You go search it in the department, you file it. How the court can grant all this?
My lord, the department will not allow me to file.
One or the another reason the court cannot adjourn, sir.
My lord, kindly appreciate, my lord, how
You file it. I am not restraining
the
you to
department don't allow me, my lord, to
You
file.
file it. I am telling you, go and file in the department.
My lord, leave can be endorsed only
What is the leave is required for filing
for the purpose of
application?
filing it in the short cause title because I am
Yes, call the
Grateful to
Lord. Yesterday at 2 p.m., I had mentioned this suit for and we had informed the department. And the department has said, unless your lordship grants the leave and your lordship's officer endorses it on the back of the plane, they will not number assign any number.
What you want actual?
But I want the plane to be filed and a number be allotted and be presented before your lordship.
File the print and place before this court.
Grateful.
Leave is granted to file the print and to place before this court.
Your Lordship,
Grateful.
this is an unaffirmed WS. The time is expiring 120 days by tomorrow. Your
Affirmed.
Lordship, we have,
Affirm the written statement.
will be done within an hour or so. Affirmation will be done within an hour.
Go and affirm and come.
Your Lordship, the application has been filed.
Application will not do, madam. If your written statement is affirmed today, you mention that I will grant leave to you.
All right.
That can only do. Yes. 10:30.
Well, I'll be very short, Mal.
Yes.
My Lord will recall the order that they are seeking, and also the addendum order my lord has passed is basically amounts according to us to attachment of the proceeds of a life insurance policy. Well, there are two sets. I'll just place the judgment 2021 SCC online Bombay 3970.
Yes.
I think it's on top. Yes. My lord, just before I place the decision, two things I want to highlight to my lord. There are two types of policies in this case. About 3.6 crores I am still to get. It is payable. And if I've written down what Mr. Chaudhary submitted, and also in effect Mr. Mukherjee, my lord, that if it is payable, then it is not to be attached. So that 3.6, we had given a chart like this one. I don't want to go into the facts. So 3.6, it's been injuncted. The prayer D is to injunct the insurance companies to pay us this money. That cannot be done. That is one. And the rest of it, which I have received, is 4.5. 4.5 I have received, and they are seeking an injunction on that, saying that once you have received the money, it no longer bears the character of an insurance policy. Now, the decision, if my lord takes the decision, it is distinguishable straight away, because in this case, the case that Mr. Mukherjee cited in reply, the policy holder was alive. The policy matured and it went into his account, and he was the judgment debtor. So they said that for you, there is no exception. But what is the policy or the principle behind section 61 KB is that it has to protect the heirs. So in our case, if the policy holder died, and Your Lordship, this judgment, while Mr. Mukherjee was reading it out also, it's very clear. They distinguish these two type of cases and say, since here the policyholder was alive, therefore I'm attaching. But it also clearly says that if the policyholder has died and it is for the benefit of the heirs, though the money goes into his estate,
Yes.
that 1984 Supreme Court basically says nominee can only take the money,
Yes.
but the money belongs to the heirs.
Yes.
And this is what is protected by this. So I'll just take my lord straight away to the decision. My learned friend first cited paragraph 1 and 6.
Yes.
And then the last 4 paragraphs. I'll just take my lord through one or few others. Paragraph 1. The short but important question that has arisen during the hearing of this IA pertains to whether or not the proceeds of an insurance policy on the life of a judgment debtor can be attached after maturity of the policy. So he is alive and it's matured, or whether under section 60, etc., the proceeds continue to be protected.
Yes.
So this was the first question, the facts. Now my lord will come to paragraph 6. Paragraph 6, I had cited one of the item 1, 2, 3, and 5 was referred to in 3.
Yes.
So 5 is there, that Pulugu is actually quoted in the item number 3. So I had cited these 4 and one more decision. That other decision, I won't go into that. My learned friend has distinguished it. That was to do with pension.
Yes.
But these 4 are to do with the proceeds of a life insurance after the policyholder dies. Now my lord will come to, these are the 2 that was cited. Now my lord will come to paragraph 8. This is the submission made on behalf of the award holder or judgment, the decree holder, my lord. Mr. Rivello submitted at the first instant oral application for vacating ought not to be entertained. That's not important. My lord, if my lord comes to the last sentence, he relies on explanation 1 to the proviso of 61 KB and submits that from the explanation, it is clear that once it is paid, the money becomes attachable. On behalf of the plaintiff, therefore, he submits that once the monies are paid and received by the policyholder, my lord will note that, it would cease to retain its character as monies payable under life insurance. Now, this paragraph 9 is very important. Mr. Rubello submits that while Mr. Chariwar in his submissions has sought to equate monies falling due under the policy of a life insurance to amounts in the Provident Fund, according to Mr. Rubello, Provident Fund dues stand on a different footing. He submitted that the legislature did not intend to place the proceeds of a life insurance on the same footing as the provident fund dues. Now, this is important. He sought to differentiate the aforesaid judgments by relying on his analysis of Federal Bank, etc. He relied upon the decision of Kerala High Court, which is such and such, and invited me to hold that the factual basis of the judgment cited by the judgment debtor contemplated payments to heirs after the death of the policy. So that is the distinguished totally. He submits none of the judgments relied by Mr. Cheriwar dealt with the question whether or not the sums paid to the policyholder on maturity were capable of attachment. Next line is a killer line. Huh? The court has held that the payments due to the heirs could not be attached. So he accepts that. In this judgment, the counsel himself, of course, this is not the finding. Mr. Ravello submits that judgment debtor should not be permitted to take shelter of 61B. It would provide a convenient route to avoid payment. That's not. So this is the main distinguishing feature. Now, my lord will come to paragraph 11. This is the court is saying. Having heard the learned counsel for the parties, the larger question to be now considered at the outset is whether the monies payable under a policy on a life of a person can be attached and appropriated by a judgment creditor upon the amounts being paid to the insured person during his lifetime. Very important distinction, because that proviso explanation that my learned friend showed,
Yes.
that refers to pension, etc., will not lose its character before or after. And provident fund, life insurance not included there.
Yes.
So before and after is the question. Now, whether the amount, once it matures, is liable to be attached. In other words, once the policy matures, the monies are paid out to the insurer during the lifetime of the assured, by the insurer during the lifetime of the assured, whether such amounts are capable of attachment. The other question is whether the direction given to Life Insurance Corporation is required to be vacated. Now, here also, Prayer D, they have sought LIC not to pay but that part I believe is conceded, that payable in future. Now, my lord will come to paragraph 17. Then paragraph 13, section 61 KB is set out.
Yes.
Paragraph 17, my lord. Now, this was a decision that is, I told my lord, it is already in that Bomianayan decision. I'll just place this quickly. In Pugulu Karnaka Reddy, the Andhra Pradesh High Court has was considering an attachment before judgment of the amounts under life insurance and held that the amounts payable on the life of the deceased were exempt from attachment. The order of the court attachment before judgment, the insurance policy amounts of a deceased borrower for recovering the amount due under a promissory note, etc., from the wife and son was not sustainable. So here, wife and daughter, or widow and daughter rather. That order of attachment before judgment was thus set aside. In course of delivering the judgment, the Andhra Pradesh High Court considered Federal Bank, and this is the 1986
Yes.
Bombay judgment, the fact that clause KB was inserted in 1976 and the Law Commission of India's 54th report. And this is the policy behind it. In order to encourage thrift, the habit of life insurance should be encouraged. And that consideration, in turn, justifies a more liberal approach as regards exemption of policies of the life insurance from attachment. No doubt, considerations justifying an exemption have to be balanced against the legitimate claims of a creditor who has taken the trouble of obtaining a decree and who is engaged in a still more troublesome venture of executing it. The less obstacles placed in his way, the better. Now, this is important. Nevertheless, on the same principle on which the monies in a certain provident fund are exempted from attachment, there is a case for exemption of monies due to the policy of life insurance. Further, we do not think there should be any time limit as to the maximum that is to be exempted. Not time limit, any limit as to the maximum that is to be exempted out of the amount of policy. So this was the reasoning behind bringing in that section. Then 18. The court therefore observed that the policy underlying incorporation of exemptions may have to be kept in mind, and that the order of attachment in that case was unsustainable. As we have seen, the facts of Bugulu Karnakar Reddy's case reveal that the amounts of the insurance policy were to be paid to the wife and son. This is important. The insurer himself having been expired. The facts at hand, however, are different in as much as the policy is maturing during the lifetime. Then, 19. And other cases are there. 19 is what I relied on.
Bhumiyana, yes.
And this, I'm just, since I've got the opportunity, I'll place it again. I've placed this judgment in full before my lord. But the decision that is being sought to distinguish this judgment relies on this judgment. Then my lord will see in Bhumiyana, the Andhra Pradesh High Court was considering the effect of 61 KB in a civil revision. A decree having been passed in the suit, the court allowed the execution petition and sought payment of the amounts from a Ganeshi insurance company. The LIC policy in that case was that of a predecessor of the judgment debtors, who was not a defendant in the suit, but when the suit was filed for recovery due against the legal representatives, the court found that no exemption could be claimed. If the policy holder is alive, the monies would have been unattachable, and even if the suit filed for recovery of the amount
And due.
holder, etc., after his death, the effect of the proviso is not taken away. Now, my lord, this is the important part. Referring to the decision of this court in Federal Bank, the Andhra Pradesh High Court also quoted from the concluding portion of the Federal Bank, which observed that the monies payable under the insurance policy are entirely exempted from attachment, irrespective of the circumstances as to whether the insurance matures during the lifetime of the assured or it becomes payable after his death. These observations in Federal Bank may require analysis, and I propose to take. Then, my lord, he analyzed, because there both were considered. Now, if my lord comes to the middle of the next page, where he's quoting Federal Bank, my lord, I'm just reading about 15 lines after clause KB, your lordship will find.
Yes.
Then he says, I say so. Now, he says, I'm afraid that the reasoning of the council cannot be accepted. I say so because, first of all, one has to bear in mind the policy of the legislature that caused exemption to be laid down. I am of the opinion, and I believe, that the legislature had exempted from attachment the monies payable under a policy of insurance on the life of a judgment debtor in order to give some security to the heirs and the legal representatives. So this is the philosophy behind why it is being cannot be attached. This being the position, even though the said monies are becoming a part and parcel of the estate of the deceased, nevertheless, the exemption laid down under KB follows the same monies. I am fortified in this view of that 1984 case is cited. So then, lastly, I'd like to show my lord. Yes, that paragraph 21. What the judge in this case says, that the finding in Federal Bank is not a part of the ratio. So I'm going on to say this. If my lord comes, the top of that page 11.
Yes.
The intention always was that the amount that may be payable in future, including the policy of insurance, cannot be attached, since upon the demise of the insured person, it is the heirs who stand to benefit. Analyzing the facts in the Federal Bank, I find that the only question that fell for consideration was whether the monies under insurance policy on the life of a judgment debtor after his demise could be attached. So he distinguishes again for that. So here, all future what is payable is also exempt. So those policies that they've got an injunction on, that, my lord, I was humbly seeking that be clarified, that LIC should pay that money. And as far as the rest is concerned, I clearly come under these cases. And finally, my lord, paragraph, these were the facts. Then I'll show, my lord, paragraph 32, which my learned friend relied on, 32 onwards. And that clearly, especially paragraph 33, is in my favor. 32.
Yes.
This court in Federal Bank considered the aspect whether the money is payable under the policy on the life of a judgment debtor after the latter's death, emphasis supplied, can be attached, or whether the payment of such monies to a nominee can be restrained in a suit for recovery of money. In the facts of that case, the bank advanced certain monies to one of its constituents. After his demise, the suit was instituted. The deceased had a life insurance issued by LIC. His widow being a nominee, the bank filed an application for attachment of the policy, very similar to our case. And the trial court granted an alternative prayer restraining the insurance corporation from paying the amount of the sum assured under the policy, much as I have done in this case. Then the suit was dismissed, it was restored. Last line, the bank sought an order in the alternate directing the defendant's widow to furnish a bank guarantee for the sum claimed. The application was dismissed on the ground that the amounts payable under the policy of insurance cannot be attached, and an appeal came to be filed from the said order. Section 61 KB of the code was relied on by the appellant, and it was contended that if the money becomes payable after death of the assured, the money forms a part of the estate and can be attached. This was their argument. Yeah. The full bench of the Allahabad High Court that the policy holder continues to hold an interest in the policy till the moment of his death, and if the policy matures during his lifetime, the benefit shall be his and not that of his nominees, and those monies may be seized. So if he dies, if he is alive, then it doesn't go to a third party. There's no one to protect. It comes to him. Then 33, my lord, it's very important. This view is seen to have been approved by the Supreme Court in Sarvati Devi, which held that under Section 39 of the Insurance Act, policyholder continues to hold the interest of the policy during the lifetime, and the nominee acquires no interest during the lifetime. On the demise of the policyholder, the amount is under the policy becomes part of his estate, which is governed by the law of succession. This is very important. In paragraph 8, the decision of Federal Bank, this court held that the view of the decision in Sarvati Devi is no longer possible to hold the view that the monies payable under an insurance policy do not form a part of the estate of the deceased. But the question before the court was not whether or not the monies would be a part and parcel of the estate. The question was whether the monies are liable to be attached for payment of a decree. The court considered the policy of the legislator and that caused the exemption to be laid down, and opined that the legislature had exempted from attachment of monies payable under the policy on the life of a judgment debtor in order to give some security to the heirs and legal representatives. It is observed that even though the monies become a part and parcel of the estate, the exemption in KB follows the same monies. Very clear. Then 34. The court concluded that the monies payable under the insurance of a life of a judgment debtor are entirely exempt from the attachment and sale by virtue of clause KV, irrespective of whether that is the finding in the Federal Bank. Yes. So this court then finally in 35, which was placed, this is the finding, considering all the above in the facts of the present case, so where the policyholder is alive, I am clearly of the view that since the policy matures during the lifetime of the assured, once the payment of the maturity value is made by the insurance company, the funds are paid out by the insurance company, the funds would lose protection under 61 KB. The safe confines of Provident Fund and pension compulsory deposits do not encompass the amounts paid on maturity of a policy of insurance. To that extent, I respectfully find the explanation of Section 60 not having been considered in the Federal Bank, the aforesaid decision was distinguished. Because Federal Bank says it applies in both cases. Here, the single judge merely distinguishes that case and says that is not the part of the ratio, that is the finding ultimately. And then 36, in the circumstances, I am not inclined to vacate the order. And that's that. So this decision clearly shows that the cases I cited are completely applicable and it's accepted. So, and two things, the ones that are payable, my learned friends have said that they have no issue with that, and the ones that have been paid, and it now forms a part of his estate, but it is for the benefit of the wife and daughter. So they cannot be touched. So this is the only thing. And two other points I want to make. I had cited 4 cases on suppression and non-vigilant, some cases. My learned friend has fairly said he doesn't oppose the no quarrel on the principle, try to distinguish each facts. Facts I've gone through in detail, and that letter that we asked them, I had treated that as a part of my submission. Your Lordship will see that from that letter that they have disclosed documents which show there were other transactions. Some may be authorized, some may not be authorized. My submission was it's a question of trial. It's a tribal issue, and therefore those were only sought to be distinguished on facts. I'm not going into that. Now, one more thing I wanted to say, which, my lord, as a matter of law, which was submitted, I think, by Mr. Chaudhary, that once I allege fraud, the burden shifts. That cannot be, my lord. Fraud has to be proved beyond reasonable doubt.
Correct.
I think I cited that decision on that also. So this thing was saying that I have suddenly got up after 5 years. The first transaction is of 2020. Some money was sent to the wife's name. And the rest of the transactions were from 21. Income tax is being paid, it's being audited by different persons. And they're saying that, no, it's not the same thing as watching a building go up in the heart of the city. You should have known. Yes.
Yes.
And as far as loans, etc. are concerned, my lord will consider once the letter that we have given. My learned friend tried to say that because your lordship did not allow our junior to file a rejoinder, they are not obliged to reply to this letter. But for 5 months, they haven't told us that. They have not replied to it. During the course of my argument, we had handed over this letter, and and they had said they will, but that letter, your lordship, it cannot just be brushed aside and said, we are not obliged to answer it. Because very important things are there. What was suppressed? So those facts, your lordship will treat as my argument, because it's from the documents in their opposition, in their reply, which show that I have been giving loans to the plaintiff's company. Now, which is authorized, unauthorized, this will have to be proved in trial. So, my lord, I'm humbly praying, my lord, that have said. My lord, the last thing is, my lord, the 2 lakhs I had asked,
Yes.
out of only thing, my lord, that money should be taken from respondent number 4's account. Earlier, it was another account. There was a Standard Chartered account. This is from the ICICI Bank account. And one last prayer I have to make is that, my lord, if your lordship is with me or not, my lord, your lordship will permit us that there are tribal issues to file a written statement, because I think they haven't filed the written statement yet. If your lordship is, if
When
it,
you
if it's sustainable.
receive the writ of summons?
Long time ago. Because of this, well, she had just recently lost her husband and it was in a mess. Now we are, because of the documents produced by them, we have been able to make out a semblance of a case. But as far as insurance policies are concerned, the rest of what has been injuncted is a property of us. Now that itself is sufficient, according to them, is worth 5 crores. That itself is sufficient security till the trial.
Which account you ask for? Which account?
ICICI account. Respondent number 4. And those are my submissions.
What is the bank account number?
Bank number.
They can probably say my number offhand, my lord, but can't remember theirs.
Number.
কোনটা দেখে নাও যেটাতে টাকা আছে
62790-150.
এই তো ICICI Bank.
That is page paragraph 12 of GA1. Paragraph 12 GA1.
Well, they'll write it down and give my lord.
No,
There are 2 ICICI Bank accounts.
no, that's a paragraph 12 GA1, page 12.
my lord, page 41 if your lordship kindly sees,
দুটো আছে এখানে।
এটা আমার এটা আমার
ওখান থেকেই দাও।
আপনাকে তো বলেছেন 69
May I be excused?
Yes.
About 10:30 before just. You will fast over. Next. Next. What's the video? Then
Counsel of the parties have concluded their argument in connection with GA1 of 2024, CAV Polygraph. The counsel for the defendant press for permitting the defendant number one. Defendant number one. Defendant number one.
one is
They want to withdraw amount 2 lakh.
dependent number one, my lord.
Dependent
Account number is 1300 1562221.
1300
150 221
1300 150
6221.
ICICI. Which branch?
My lord, I'll tell you, it's Lake
Road branch.
My lord, Saurabh Postal. My lord, it's here, my lord, at page 42.
42. Yes.
Page 42, my lord, first account.
Okay. Aki will press for permitting the defendant number one to withdraw a sum of rupees 2 lakhs for the expenditure for the expenditure of the defendant number one and the defendant number two. Defendant number two. We submit that on the earlier occasion by an order dated 3rd October 2024, the Honorable Division Bench has allowed the defendant number one to withdraw the sum of rupees 24 lakhs. Accordingly, the defendant number one may further be allowed to withdraw further amount of rupees 2 lakhs from the ICICI Bank, being account number 130001506211, Lake Road branch. Lake Road. Then counsel for the plaintiff submits that without prejudice to the rights and contention of the parties, the defendant number one may be allowed to withdraw the said amount. Accordingly, the defendant number one is permitted to withdraw a sum of rupees 2 lakhs from account number 130001506221 of ICICI Bank, Lake Road branch. Lake Road branch. Lake Road branch. Police.
My lord, I had, my lord, said, my lord, one time for puja. My lord, that's why I kindly provided.
The क्या बोला? The ऊपर बोला ना counsel for the
Looked at
plaintiff.
her Facebook
Submit
account.
that.
Holiday
The
pictures.
plaintiff. अरे बीच में बोला ना counsel for the plaintiff. उससे पहले counsel for the plaintiff.
Carefully designed top list.
Submit that as the plaintiff, as the defendant number one, prays for withdrawal of the amount for the purpose of puja. Accordingly, without.
And my lord, I didn't object to it. Kindly, my lord.
Accordingly, he has not objected for withdrawal of the said
It could
amount
not be treated as a
but
precedent. That was
without
my
prejudice to the rights and contention of the parties. ठीक है?
And my lord, the interim order needs to be extended.
The interim order granted earlier is extended till the disposal of the said.
Okay.
Even for the policies that are payable.
Yes, yes.
Till the disposal of, till the final order of this application. Till the final order of this. 11 PM. हाँ, कहाँ है? कल करो, छोड़ दो, कॉल फिक्स मैटर करो.
It should be on this side.
আমরা এদিকে
Now, my lord, just two submissions, my lord, apropos, my lord, the 12A and my lord, the petition which has been filed.
Yes.
My lord, by my learned friends.
You are appearing for?
My lord, I appear for respond numbers 16 to 18, my lord.
Yes.
Now, my lord, 2 points, my lord, with regard to, my lord, the urgency, etc., my lord, which has been, my lord,
Yes.
referred to. My lord, kindly take, my lord, a document, my lord, which is, my lord, which, my lord, has been annexed, my lord, to the plaint itself, to the petition also. My lord, kindly take, your lordships have the plaint, my lord. Joy, plaint touch it.
Plaint hai?
Plaint, I'm told, is there, my lord.
वही तुम बोला है
हो जाएगा, ठीक है, plaint,
okay hearing just once hearing is going on why you are not calling the plaint उस दिन भी हम बोला आप लोगों को
আমি annexure গুলো চাইছি আমার পেজ নাম্বার গুলো বলে দাও কোন কপিটা চাই হ্যাঁ বলছি my lord my lord, your lordship takes the petition, my lord. I'm sure it's there, my lord, in the petition. My lord, these are all annexures to the plaint. Your lordship may make a note of it. My lord, what has been challenged, my lord, in the suit are a series of transfers, my lord, which have happened with respect to certain shareholdings, which they say, my lord, is in violation of, my lord, undertakings contained in the guarantee and the supplementary guarantee. Sit. Now, my lord, I just want to show your lordships, and my lord, Section 12A leave, my lord, has been obtained on the basis that, my lord, they came to learn of these transfers and the fraud only upon filing of, my lord, the, my lord, forensic report.
Correct.
Now, my lord, most important, kindly have a look, my lord, at, my lord, I start with annexure LL to the plaint, my lord, which is, my lord, volume 8, page 1108 of the plaint, which is it of the petition? And, my lord, in the petition,
yes in petition
my lord, it should be, my lord. We have the petition. Don't go to sleep. No, just find the petition page number. 1108. Lord, it should be 1121, my lord. I don't know.
1108.
that is the plaint
Yes, my lord, plaint they have, my lord, so they can, my lord, hand up. My lord, I want to know what it is in the petition, which
yes
now, my lord, this is, my lord, filed, my lord, on, my lord, 20th of February 2017. The government is there. Huh? My lord, kindly take, my lord, why print page? My lord, 1121. My lord, your lordship sees the digital signatures at the bottom, my lord.
yes Rohit Agrawal Sanjay Kumar
Yes. My lord, it is. My lord, first is the month, my lord. Here, my lord, is my lord 2017.
March 2017.
Yes.
3rd March 2017, that is the order.
Yes. Now, my lord, no, it should be, my lord, 23rd, my lord, 20th February 2017. Oh, my lord, 3/10/2000. I'm sorry, my lord, 3/10/2017.
Where we got?
My lord, kindly see the, my lord, Agarwal Sanjay Kumar. My,
Hmm.
Your lordship has that box.
Yes.
Now, my lord, in that box, the second last entry. My lord, kindly start from the right-hand side.
Hmm.
3rd October 2000, my lord, 17. 3, your lordship sees.
Yes.
My lord, the American system, my lord.
Yes. Yes.
My lord, it's gone, my lord, 3/10/2017.
Okay.
Now, my lord, this, my lord, your lordship will find this document. My lord, gives, my lord, at page 1125. 1125, my lord, the, my lord, list of shareholders. Now, 1125 hobe na? Yes.
Yes. Yes.
My lord, I'm on the handwritten, my lord, page number 1125, your lordship has. My lord, this says kindly see names of shareholders, etc., my lord, of the concerned company. 2017.
Yes.
Now, my lord, kindly come to, my lord, 28th, document of 28th November, which is Annexure MM, my lord, volume 8 of the plaint. My lord, 1128.
Yes.
And my lord, the digital signature your lordships will find, my lord, at page 1141.
Yes.
My lord, just for completeness sake, my lord, I should. My lord, 1141 your lordship will find before the digital signature, my lord, there's a declaration. Lordship has that, my lord,
Yes.
declaration.
Yes.
Now, this is pursuant to resolution of the company dated 9th August 2018. Now, my lord, kindly, I don't know how, my lord, legible your lordship's copy is. My lord, the date is, my lord, 28/11/2018.
Yes.
My lord, if it's not legible, my lord, we can, my lord, have a printout taken
Date-
now.
Dated
my
is,
lord-
I am authorized
My
by
lord,
the.
under Aditya Kumar Agarwal, my lord.
Yes, Aditya Kumar Agarwal.
Yes, the last entry, my lord,
Yes.
is the date. I don't know if that's legible, my lord.
Date is not legible.
My lord, I'll get a printout, my lord. It is showing. Yes. My lord, I can show it from the iPad, my lord. I can, if your lordship takes that 1 minute.
ये ma'am. Print mango.
My lord, if your lordship has a look at.
बोले. (28/11/2018).
Yes, your lordship has that, my lord. Now, my lord, important thing is I want to show the transfers. My lord, kindly take, my lord, 1149. My lord, this, my lord, also gives, my lord, the details of, my lord, transfers. Lordships will find, my lord, details of shares transferred. First 4 entries, my lord. Defendant numbers 1 to 4, my lord.
Yes.
My lord, which were, my lord, being referred to that they have transferred shares, my lord, transfer is there. Now, my lord, my lord, come into the picture. My lord, subsequently, my lord, kindly take annexure NN at page 1150. My lord, of the plaint.
1150.
Yes, ma'am.
Yes.
One before the plaint. Now, my lord, kindly turn to, my lord, 1165.
Yes.
My lord, items 6, 8, and my lord, 25.
Yes.
Are, my lord, the defendant numbers 16 to 18.
Yes.
And my lord, the uploading, my lord, is 25th November 2019. The signature, my lord, your lordship kindly sees. Yeah, that's okay.
Hello.
I'll give the page number, my lord. And and if your lordship's, my lord, copy is not legible, my lord, I can, my lord, just,
Page number.
my lord, this is, which page is page 14? 1163, my lord.
1168.
63, 1163. I don't know if it's legible.
No.
And my lord, 25th November 2019.
Yes.
So, my lord, I come into the picture from now, and today, my lord, we are in, my lord, 2025. My lord, when any order of injunction is being sought, my lord, against me. Now, my lord, 4th. Now, what your lordships have not been, lordship has not been told. If the decree had not been the order. My lord, kindly have a look at the prayers, my lord, in the plaint. My lord, it starts, my lord, at page 61. Oh, my lord, kindly have a look, my lord, that these prayers, my lord, which are being sought, that kindly come straight away, my lord, to prayer F.
There is no plaint. You are having the plaint.
Plainted first page ka hai? Yeah, just give me. My lord, it's an annexure to the application for revocation. My lord, the plaint without the annexures.
A revocation application the most.
Page 98, my lord.
J2, J2. Yes, page 98.
Oh, my lord. kindly come to, my lord, prayer, my lord. Prayer C, my lord. This is directly, my lord, against me. And, my lord, which is in the public domain, my lord, in 2019.
Yes.
Then, my lord, kindly come to, my lord, page prayer G at page 100.
Yes.
Then, my lord, this is, my lord, cancellation of issuance, transfer of shareholding of defendant number 16 to 18 in favor of defendant numbers 19 and 20. So, my lord, prayer F. Prayer F. Decree delay transfer of shares belonging to 5 to 15 in defendant numbers 26 in favor of 16 to 18. So, my lord, these are, my lord, transfers made in my favor, my lord, which are, my lord, being challenged. Now, my lord, interestingly, my lord, there is, my lord, a challenge. Prayer H, prayer I, prayer J, my lord, my lord, which, my lord, deal with a settlement agreement. Show the forensic report. Take out the order. Order settlement.
Yes.
Now, my lord, kindly take the forensic report. Which page is it? Volume 9, my lord. My lord, it starts at page 1314 of the plaint. Settlement agreement. Delhi High Court mediation center.
Yes.
My lord, this is, my lord, in volume.
Yes, got it.
Yes. Kindly take,
1314.
yes, kindly come to 1374, which is in volume 10. My lord, expresso.
Page?
My lord, page, my lord, 1374.
Yes.
Now, my lord, the settlement agreement, my lord, is challenged. And, my lord, then, my lord, kindly see clause 4. On
Share allotment.
25th November 2022, company has allotted to the following foreign companies as per settlement agreement, so and so these shares. And settlement agreement, your lordship seen, my lord, the plain. My lord, which is annexure, my lord, RR.
Yes.
Show the above maps in the plaint first. Now, my lord, kindly take the plaint once. I want to show, my lord, where the,
Yeah,
my lord, kindly take the revocation. Plaint is annexed to the revocation. No, that's why I'm.
Yes.
Not the prayers, the averment. No, you did not. My lord, kindly have a look at the averment. My lord, paragraph 37. My lord, this is, my lord, at page 38, my lord.
Yes.
Now, Millard, kindly come to Millard. Millard, para 37B first.
Yes.
Now kindly see, defend numbers 5 to 15 in the financial year 2018-19 transferred their shareholdings in defend number 26 equally to defend number 16 to 18 as per particulars. So financial year given, how did they know it? Kindly see. After the table, the aforesaid transfer is evident from form MGT 7 along with list of shareholders for financial year 2017-18 already annexed here to and marked as MM, and form MGT 7 along with list of shareholders for financial year 18-19 of defend number 26, which is further annexed here to and marked blank. Then Millard, kindly come to Millard H, subclause H.
Yes.
Certain purported disputes between 16 to 18 and defendants 19 and 20 were referred to arbitration that culminated into an award. The said award was challenged before the Honorable Delhi High Court. Honorable Delhi High Court referred the matter to Delhi High Court Mediation and Conciliation Center. In the said mediation proceedings on 22nd March 2022, a settlement had been arrived at between the aforesaid companies, whereby 85% of shareholding in 16 to 18 were issued equally to 19 and 20. The issuance of 85% of aforesaid has affected the transfer of control of shares of defend number 26 from 1 to 4 to the hands of foreign entities. Copy of the settlement agreement dated 22nd March 2022 is annexed here to and marked blank. Now, Millard, this was a settlement. Now, Millard, everything they know. One important thing, Millard, they don't mention at all. Let's show the final. No, copy though, Millard, everything they know.
Yes.
Now, Millard, kindly see there's an order of the Delhi High Court.
Yes.
Kindly see the order, Millard. Petitioners impugn award dated so and so by way of this petition under 34 of Arbitration and Conciliation Act. Petition and respondents were referred to mediation and a settlement agreement dated so and so has been executed between the parties. Petitioners are represented by Hemant Rathi and respondents are represented. Both authorized are also connected. In terms of settlement agreement, parties have agreed to modify the award to a limited extent and claim of interest and cost is being waived by respondents. Authorized representatives of petitioners respondents submit that they are authorized on behalf of the risk to shall abide by the. Now kindly see 6. I have perused the terms and conditions of the settlement agreement and find the same to be lawful. Undertakings given to the court are accepted. Petitions are accordingly disposed of in terms of the settlement agreement dated so and so. Parties shall remain bound by the terms and conditions of the same and perform their respective obligations as agreed in the settlement agreement. Now, my lord, two important things. My lord, there is no challenge, my lord, to this order.
Yes.
Second, my lord, there is a finding in this order that, my lord, memorandum of, my lord, settlement, my lord, is, my lord, lawful. Now, my lord, this order has to go, my lord, and how will it go? It can't go in this suit. My lord, it has to be filed before the court, my lord, which recorded that this was lawful. Now, my lord, if this is the position today, my lord, I say two things. My lord, no case made out, my lord, for, my lord, section 12A leave on the face of it.
Yes.
And, my lord, number two, and this is, my lord, very important, my lord, they have suppressed, my lord, this order. All orders, my lord, of the Delhi High Court are on the website. They followed Delhi High Court Mediation Center and they don't know this. And the forensic report also decides not to make reference to this. It's unbelievable.
Yes.
My lord, the plaint, my lord, surprisingly makes, my lord, a reference to Delhi High Court order to, my lord, send it to mediation. My lord, I'll show that. But, my lord, what happens after mediation? There's a settlement agreement. And, my lord, this is also recorded. My lord, is not mentioned. I give the reference in the plaint. My lord, 37H, which I read out. My lord, that Delhi High Court referred it to mediation.
Yes, arrived between the company.
Yes.
Same as this decree, same.
Copy of the settlement agreement is annexed.
Annex this, Murad. This is annex to my
Annex, yes.
this settlement agreement.
Yes, annex.
Yes, yes, settlement agreement is annexed. Not, my lord, the order. So order of court, my lord, in a 37, 34, where, my lord, the award was challenged. Settlement, my lord, court, they say court sent it to mediation. In mediation, there was a settlement agreement. What they don't tell your lordship, my lord, on the basis of settlement agreement, 34 got disposed of. Where, my lord, the award was modified. Now, my lord, with the greatest of respect, I have just 2 points. No urgency here, my lord, because, my lord, of 12A. So, my lord, leave should be revoked because this transaction took place in 2019, of which they are aware. And, my lord, lastly, my lord, the settlement agreement is not merely an agreement between the parties. It has the imprimatur of court in an order, my lord, passed in a section 34, where, my lord, the court has found, my lord, the agreement to be lawful. If they have, my lord, any, my lord, issue with that, my lord, they have to, my lord, apply, my lord, for, my lord, setting aside of that order. And that can only be done in that court. And that matter has been suppressed. So, my lord, really, my lord, at this stage, your lordships, my lord, will not, my lord, entertain the suit at all.
Yes.
My lord, I have not addressed, my lord, on merits as such. My lord, on the face of it, my lord, this is, my lord, what, my lord, I say, my lord, that it being, my lord, and first, my lord, really, my lord, issue, my lord, which arises at the threshold, my lord, should be decided. It's, my lord, inherent, my lord, lack of jurisdiction. In
Thank
fact, your lordships are aware, my lord, 12A, my lord, today, there doesn't even have to be an application.
Yes. It's verbal.
My lord, it can be done suo moto because an Order 7, Rule 11, partial automation, which Mr. Bose handed up yesterday, says, my lord, that it can be done suo moto. My lord, those are my submissions.
No, I have prepared a short notes on the points with page numbers. I will hand it over and with a copy to them. I will not added anything more, but you are noting down, so I made it.
I shall take very short. Well, everything has been argued. I would
You are
not want to
appearing for
repeat. But I am appearing 5 to 15.
5 to 15.
Yes. But I will just refer your lordship to my lord, their own plaint. I will not trouble your lordship with the plaint. The same thing has been stated in the petition itself. Kindly, my lord, take the petition. I will rely upon only.
ये उनको दे दो.
Kindly, my lord, come to the petition, paragraph 37 at page 46.
37
Para
of the
37
application.
of petition. Para
37.
yes, page 46, I think, in the petition, if I am right.
Yes.
No, my lord, I just don't want to trouble your lordship. This is what they have said. Now, kindly come to in the form of subparagraphs, several subparagraphs, A, B, C, D, etc. Kindly come to page 52. This is what they have said. So they know. Certain purported disputes. No, first of all, my lord, I think before your lordship will kindly come to paragraph 37 once, page 46. I'm sorry, my lord, I have to take your lordship back to para 37 at page 46.
Yes.
It says that in order to defeat and defraud the petitioners and each of them, and in order to ensure that the said shares belonging to the respondent 1 to 15 could not be attached and or taken possession of, and or enforced and or encashed by the petitioner, the respondents and each of them, including the pro forma respondent, prior to its admission into insolvency, spun an intricate web so as to make infructuous and or render nugatory the said deeds of personal and corporate guarantee. Particulars in this regard are as follows. Well, Lord, kindly come. I am not troubling your lordship with the other paragraphs, subparagraphs. Kindly come to page 52, subparagraph H. So this is what they say. Certain purported disputes. This is what Mr. Mukherjee has just now argued, between the respondent number 15 and 16 to 18 and respondent number 19 and 20 was referred to arbitration that culminated into an award. They themselves are saying the said award was challenged before the Honorable Delhi High Court. The Honorable Delhi High Court referred the matter to the Delhi High Court Mediation and Conciliation Center. Now, this is, my lord, has been verified. Well, in the next paragraphs, next subparagraph, my lord, if your lordship kindly takes there, in the said mediation proceedings on 22nd March 2022, a settlement had been arrived at between the aforesaid companies, whereby 85% of the shareholding of the respondent number 16 to 18 were issued equally to respondent number 19 and 20. This issuance of 85% share of the aforesaid respondent number 16 to 18 has effected the transfer of control of share of respondent number 26 from respondent number 1 to 4 and the hand of foreign entities. That is the respondent number 19 and 20. Mr. Mukherjee was appearing for it. Copy of the settlement agreement, etc. Then, my lord, kindly come to, in this circumstance, kindly come to page 61. I am not troubling your lordship to move from one document to another document. In the same document, my lord, the prayers in the plaint have been set out.
Yes.
Now, these are the state, after the state, and kindly note this, subparagraph H and I, which I just now placed before lordship, has been verified as information received. Therefore, my lord, all the information they must have
had the
received
knowledge,
and
yes.
believed by them to be true. Now, my lord, in such circumstances, what are the prayers? Declaration: the shares of defendant number 26 held by defendant number 1 to 15 in the manner stated in annexure TT constitute security into the plaintiff and are incapable of being sold, transferred, alienated, etc. Then B, declaration: the transfer of the said shares belonging to defendant number 1 to 4 to defendant number 21, 25 more fully and particularly stated in the schedule being so and so is illegal, unlawful. Then prayer C. This, my lord, we have followed by this prayer C, D, E. My lord, kindly see prayer C. Declaration that the transfer of the said shares belonging to defendant number 5 to 15 to defendant number 16 to 18 more fully and particularly stated in the schedule being so and so is illegal, unlawful, fraudulent, and null and void. My lord, these shares had been transferred, my lord,
The settlement.
to defendant number 16 to 18 pursuant to an award.
Correct. The settlement.
Your lordship has been pleased to see that award is dated 23rd August 2018. Your lordship can kindly make a note of it that this has been transferred in 2018. Then, my lord, D. D is declaration
What is the award dated?
of the shareholding of defendant number so and so.
What is the award dated, Mr. Mitru? Award dated?
Award dated, my lord, 23rd August 2018.
Yes.
Then, my lord, D. Declaration that the transfer of the shareholding of defendant so and so, more fully particularly stated in so and so, is illegal, unlawful, fraudulent, and null and void. This has been transferred pursuant to the award dated 2nd December 2019.
Yes.
So these are all, my lord, transfer in terms of an award. My lord, one award has been paid, passed by the learned district judge Calcutta, and the other is the High Court judge, retired High Court judge in Delhi High Court. So, my lord, these are the two awards. One is 23rd August 2018, the other is 2nd December 2019. Then, my lord, this award was challenged before the Delhi High Court under Section 34. And, my lord, Delhi High Court sent it to mediation, what they have said. And the settlement before the mediator took place on 22nd March 2022. So that also 3 years have gone by. And this settlement was recorded by the Delhi High Court in Section 34 application on 19 April 2022.
Yes, 19th April.
19th April 2022. So, my lord, these transactions are complete in 2022, started from 2018 and 2022. all, my lord, having the imprimatur or the seal of the court. And this they are seeking to have declaration. First of all, I will submit to your lordship, perhaps it is not maintainable before lordship. But quite apart from anything else, I say, how can they, my lord, obtain live under section 12A? When, my lord, the transactions have taken place between 18 and 22, and today in 2025, they are coming for lordship under section.
Yes.
Well, I adopt the submissions, my lord, made by Mr. Bose and Mr. Mukherjee, and I submit to your lordship on the basis of the plaint itself. Your lordship can, my lord, come to the conclusion that there had been inordinate delay, which will not entitle them to, my lord, take leave under section 12. These are my responses.
Thank you. Yes.
I appear for D21 to D25. Of course, because I'm not going to repeat what the learned seniors have already argued, because my submissions are consistent, and to that extent, my lords, I'm adopting the submissions. Only few points I'm going to take your lordships through with your lordship's kind permission. Lordships will have the
The good
plaint.
name?
Lords Adarsh Ramanujan. Adarsh Ramanujan. My lord will have the plaint. The specific prayers, my lord.
Yes.
Against me.
Yes.
Lordship will have prayer B.
(21 to 25).
That's right, my lord. So the share transfer from D1 to D4.
Yes.
In my favor, they want a declaration is null and void.
Yes.
Plus D, prayer E for elephant, for delivery up, the same shares.
Yes.
So my sequitur, from whatever I'm going to make, are only twofold. Plus one, the suit goes under 12A. The suit must go under 12A for the reason that I'm going to highlight to your lordships. Two, worst case scenario, lords, no ad interim without an affidavit from my side.
No ad interim?
Without an affidavit from my side, because there is much that has been suppressed by the plaintiff. So, my lord, suppression alone is a ground under 12A. Your lordships have already held that. The Supreme Court has already held it. My lord, therefore, I need that opportunity to present the correct facts to your lordships. Now, my lords will have the same annexure LL that the learned senior Mr. Mukherjee has already referred to. Because the case is, my lords, the transaction took place in 1718, but I came to know only in May. Now, annexure LL to the plaint, lordships will have 1125, which, my lords, gives the shareholding of D26. I'm not going to take your lordships to that. Mr. Mukherjee has already shown that specific page. I'm relying on the same page because the very same public documents that were uploaded qua D26, that is the company in which the shares are, the disputed shares. That company's publicly uploaded form also disclosed the share transfer from D1, D4 to D21, D25. Because it was certainly within, therefore, public knowledge. And my lords, an allegation of fraud, my lord, does not help them today if, my lords, the fraud could have been discovered from public documents. Especially, my lords, the very interesting point is the whole case runs around that audit report, which is annexure SS. The audit report, my lords, I don't know if your lordship's paper book is clean because my copies are not, but I had a separate copy taken out, my lords. At 4 different pages, specifically says the conclusions I'm drawing is all from public record, nothing else.
Which page?
Yes, my lords. Lordships will have one.
Annexure LL, which page?
Annexure SS.
Which page? Page number?
Starts at 1314.
Yeah.
That's volume number 9. But, my lord, specifically, I want to show to your lordships 1332.
Volume 9, though.
Perhaps, my lord, 1332 goes to volume 10. I don't know. My lords, I have it as a single file, so.
Then
Thus, it's in 10. Right. Lordship has a legible copy. This. Lord, otherwise, my lords, I will.
1332.
1332, my lord has.
Yes.
Because that I think is legible enough.
That is eligible.
Lord, your lordship will see the second paragraph. Just the one line.
Yes.
On reviewing the public document of SFAL available at the MCA portal. Lordship may mark that.
MCA portal, yes.
This is what, my lords, is annexure LL. Similarly, my lords, 1336.
Yes.
First bullet
Yes.
under 1336.
Upon review
of the public documents available at the MCA portal of the companies, in which the personal guarantor, specifically my lords D1 to D4, who had transferred it to me.
Yes. Yes.
Lords, a third page. My lords, is 1376. The last line, my lords, of that page. This report, I'm so sorry. This, my lords, the disclaimer given by the auditor.
Yes.
Serial number 7 at the bottom. This report is based on information obtained as a result of online fieldwork carried out at MCA portal. And my lords, last, I won't read it, my lords. It's at page 1321. I'm so sorry, my lords. I'm taking your lordships back. 1321. Third bullet, my lords, under the broad approach.
Yes.
Third bullet will say, my lords, review of public documents download from MCA portal. So, my lord, it is not as if this audit report, my lords, waved a magic wand and came up with these conclusions. They looked at what is available in the public domain. And my lords, were a respected set of plaintiff banks to say that, oh, I had no idea it's available in the public domain. I'm so sorry. It's not it's not a credible statement, my lords, that your lordship should accept at this ad interim stage, certainly. And certainly for the purpose of 12A, when my lords, the Supreme Court has held, it's an absolutely mandatory requirement.
Yes.
Not only that, very interestingly, my lords, the way the plaint is addressed, specifically the personal guarantors who were then transferred it to me. Lordships will kindly have paragraph number 37 of the plaint.
Okay, print
That is where, my lords, 37A. In the plaint, it's at page 38 of the plaint, at the bottom of page 38 of the plaint. Internal page 38, para 37. Yes. And my lords, at paragraph A, which is at page 39, defendant number 1 to 4. I am on para 37A.
Yes.
The same, my lords, defendant 1 to 4 transfer the shareholding so and so on 26 December 2017. Kindly mark the date. And after, my lords, the table overleaf.
Yes.
Just below that table.
Yes.
And my lords, the annexures are marked. It will say copies of MGT 7. So, my lords, the reliance, therefore, for them to argue that I had done the transfer is again that same MGT 7 annexure LL. So, my lords, it is beyond comprehension, my lords, for a plaintiff to say that
they are not knowledge.
And that there is an urgency. It's a false sense of urgency being created. And kindly note, my lords, just adding, not that, my lord, it should be taken against me in any way. The transfer allegedly fraudulently done, according to them, from D1 to D4 to D21 to D25 is 2017. Because we are in 2025. There's no allegation that from 17 to 25 I have done some any transfer. There's no allegation. So for 9 years I don't transfer, they don't have a problem. But they come to the court, my lords, in tearing urgency to request your lordships to give an ad interim without an affidavit from me, As well, my lords, heavens will fall if I am given the opportunity to file an affidavit in 2 weeks. If I have not transferred it in 9 years. Now, the more critical thing, my lords, will have para 45 of the plaint. Well, I'm not going to bombard your lordships with documents they have suppressed, but I'm going to point out. I'm going to point out something, and that is something they will have to answer. So there's much they have suppressed. Lordships will have para 45.
Yes.
Lords, the first 5 lines deal with the CIRP initiated by the plaintiff under the IBC against the company. Your lordships will have the 7th line on that paragraph, which is accordingly, comma. My lord has that?
Yes.
Accordingly, comma, on or about 17 July 2021, Central Bank of India, being plaintiff number 1, above named, instituted personal insolvency proceeding against D1 to D4 under the provisions of section 95 of the IBC. The said application has been numbered so and so. Don't give anything. Plus 4 numbers are given. And my lord's overleaf. Please see this innocuous tail to that paragraph. The same are pending adjudication. It's a very innocuous. I'm not saying they're wrong. It is pending adjudication. But what is not disclosed to your lordship is actually what happened in that proceeding. With your lordship's kind permission, may I take your lordships to 2 sections of the IBC? Your lordships may kindly have IBC.
Yes.
I have many arguments to say in IBC. I'm not going to argue everything because your lordship doesn't need all of that today to adjudicate on the present short issue. Your lordship will only have when a section 95 is filed. Section 95 is the application by the creditor.
Yes.
97 is the appointment of the RP.
Correct.
Now 99 4. Kindly note 99.4. The resolution professional may seek further information or explanation in connection with the application to me.
Yes.
So the RP seeks information from me and I give information to the RP. RP then gives the report. Based on that, the section 100 proceeding takes place.
Admission. Audition.
Admission. Now, lords, in my case, there is no dispute that in 2021, the admission has happened. There's no dispute on that. Now, see what, my lords, happens after this. 107. So this is when, once the admission happens, there is a committee of creditors even here. So 107 is titled Summoning of Meeting of Creditors. The resolution professional shall issue a notice calling a meeting of creditors who's them. And my lord, the meeting is prepared in accordance with 104. Now please see 3. The notice under 1. So the notice he first issues to the COC shall state the address of the adjudicating authority, report of the resolution professional, and shall be accompanied, my lords, kindly not B. Copy of the statement of affairs of the debtor, which is D1 to D4.
Correct.
Now your lordships will have the regulations. These are the CIRP regulations, my lord, for personal guarantors.
Yes.
Lord, enacted in 2019. CIRP regulation. Don't have it. Lord has regulation 10.
Regulation 10.
Regulation 10, my lords, 2019 for personal guarantors.
Yes.
Amended, my lords, I think, if I'm not wrong, on March 2025, but my lords, in force since 2019. My lords, 10(2)(a). Kindly have that, my lords. What is part of the state of affairs? Assets and liabilities of the debtor. So, in that CIRP proceeding, which they innocuously say is quote-unquote pending, the statutory procedure under the IBC was, the RP seeks every piece of information from me, prepares a report on my assets and liabilities, which means if I held shares, if D1 to D4 held shares in that company, it would have come. If they did not hold shares, it will not come. And this has happened when, my lords? 2021 afterwards. So between 2021 and 2022, all of these reports are ready in the IBC proceeding. The share transaction in my favor is 2017 December.
2021, 2022 as part of a statutory process, they get access to this information. Lords, where is that in the plain? They know for a fact, my lords, that I do not have this D1 to D4 did not have these shares. It was transferred in my favor.
Yes.
So, my lords, a false sense of urgency. So, this is the other suppression, my lords, that I was indicating.
Yes.
That if part of the IBC process, by law, they had access to this information, how can they argue today, my lords, that they had no knowledge of this before May 2025? And, my lords, last but not the least, so this argument only applies to me, D4 to D20, D21 to D25, where the shares from D1 to D4. It does not apply to the client Mr. Mukherjee or Mr. Mitra represents. Lords, these shares in that company were part of a family settlement and arrangement, which is the reason why they were never given as a collateral. Now, my lords, as an officer of the court, my lords, it is my bounden duty, my lords, to disclose to your lordships that there was a dispute between the family members on the shares held in this company, Sham Ferro, and that dispute, my lords, ended up in a partition suit. There was an ad interim passed in that partition suit. Sorry, there was absence of that in the single judge, my lords. So the matter went on appeal to the division bench. My lords, and there is a judgment of this honorable court in the division bench, where, my lords, all the family members have been restrained. My lords, it's not as if, my lords, I'm trying to play hot and cold or in any way. All I'm saying is the suit is even not maintainable, but as an officer of the court, I must disclose that there is a relevant order that your lordships must see.
Was a bank party.
So, bank order. Lordships will have. I'm only saying this, my lords, because tomorrow I must, my lords, as an officer of the court, I must disclose in all honesty and fairness. My lordships will see in page 2, the third paragraph. The Goyals are a rich family business. There is an alleged family settlement between its members concerning their shares in the company Sham Ferro Alloys Limited. Kindly only this sentence your lordships will read. This is the subject matter of the present suit also. And D1 to D25 are the family members who are also respondents in this appeal. Now, my lords may flip over. I'm not going to read everything, my lords. Your lordships need not go into the reasons for the family dispute. My lords, on page 4.
Yes.
Last paragraph at the bottom. Considering all the above circumstances, we are of the view that these applications should be heard out on affidavits by the learned single judge. In the interim period, we restrain the parties from altering the status quo with regard to the holding and dealing of the shares held by family or family members. D1 to D25 are parties, my lords. My lords, your lordships will permit me. We will file the memo appeal so that your lordship has the full. But my lords, my instructions are R20 in this appeal is D21 before your lordships. R23. I'm so sorry. May I repeat?
R22?
R20 is D21 here.
Okay.
R21 is D23 here. R22 is D24. And R24 is D25. Lords,
Yes.
your lordship's permission, was my friend before lunch, my lords will hand over a copy of the memo appeal. You can hand over.
Yes.
No, this is the appeal.
Appeal.
Yeah, appeal could have been. What are these?
My lords, I would have, of course, my lords, brought all of this on record if the suit is maintainable and I have to file an affidavit in reply, affidavit in opposition. I would have brought this on record. But since, my lords, arguments are being pressed on an ad interim, when the suit itself is not maintainable, I thought, my lords, as an officer, I have to be fair and disclose this to your lordships.
Thank you.
That there is an order to this effect. I'm grateful, my lords. And therefore, the suit goes, my lords, for suppression in 12A. And, my lords, even if the suit is by any chance, my lords, it should not be. And without it is maintainable, my lords, I must be given the opportunity to file an affidavit in opposition, my lords, before any interim order. I'm grateful for the opportunity.
Thank you. Thank you. Yes. Hey, mentor which head?
The relay race is quite long.
The relay race.
The bar has benefited from Mr. Shah's suit, my lord, before the vacation.
The relay race is quite
20
long.
odd, 27 odd defendants. No, other than, I don't know about the litigants, but the bar has been benefited. It's a puja bonus. But I have
Court also benefit time we saved.
Well,
27 people saying the same thing.
19 and 20. I will not repeat anything.
Has seen the order handed up by Mr. Raman.
Which order? I have not seen.
Kindly see that order.
Key order, actually. Kindly give me half a minute, please, my lord.
19 and 20.
Yes. I appear for 19 and 20, my lord. We are two companies. Yeah. Whatever it is, my lord, today I am not bound by this order. I am not party to this proceeding. Unless Mr. Ghosh has some information that I am party to these proceedings, I am not bound by this order. The shares are now coming to me. So this, I don't know, my lord, why he is troubling me with this, my lord.
I did trouble.
Very good. Now, my lord, kindly see 19.
Mr. Ghosh is giving information to you. Mr. Ramanujam has
Very cooperative, my lord. That's why he is.
Well, I am not affected by this order. I am companies based in Hong Kong. I don't know, my lord, why this order is shown. Now, my lord, your lordship has perhaps now been shown the settlement agreement your lordship has seen. The settlement agreement between the defendant numbers 19 and 20, that is my clients, and the defendant numbers 16 and 18, arising out of the mediation proceedings referred by the Honorable Delhi High Court. That settlement agreement was in the mediation arising from a Section 34 application after an award in my favor of $40 million. To get any kind of injunctive relief today, my lord, it must be a prima facie conclusion has to be drawn by your lordship that this settlement agreement is fraudulent. Without coming to that prima facie conclusion, no interim order can be passed restraining me or having any bearing on the settlement agreement. I have not, my lord, I will be corrected, my lord, but I have not heard any submissions as to why the transactions between companies in Hong Kong and the other defendants are said to be fraudulent or that the award is fraudulent.
Yes.
There are no submissions. Number one. Number two, my lord, the settlement agreement has now merged with the order passed by the Honorable Delhi High Court, which is the order dated 19th April 2022. I don't know, my lord, your lordship has been...
Mr. Mitra has given.
Mr. Mitra has given. Your lordship kindly sees the order once, my lord. The Honorable Delhi High Court records...
Sorry, Mr. Mukherjee has given.
My lord. Kindly see the order once, please, my lord. Because this is necessary under the code. Now I'll show your lordship why this is necessary. Kindly come to paragraph 6. I have perused the terms and conditions of the settlement agreement and find the same to be lawful.
Yes.
This, my lord, the Honorable Delhi High Court was obligated to do in terms of Order 23. Kindly have Order 23 once, please, my lord.
Give the CPC.
Order 23. 23. Kindly see Order 23, Rule 3. This was the bounden duty of the Honorable High Court.
Yes.
Kindly see, my lord, where it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part by any lawful agreement or compromise in writing signed by the... Kindly see the words, my lord, lawful agreement. So the same principles will apply, my lord, to all proceedings as the Arbitration Act also provides, and the matter comes to court, it will be guided by the civil. Now, my lord, the consequence of this is that when the settlement has now merged with the order of the Honorable High Court, and the High Court has found this is lawful, the relief sought in the plaint here, my lord, kindly have now, my lord, press H of the plaint. And without your lordship coming to a prima facie conclusion on this, no injunctive relief on the shares can be made. Kindly see prayer H of the plaint once, please, my lord. Declaration that the settlement agreement... I'm so sorry, my lord.
Yes.
Declaration that the settlement agreement between the defendant numbers 16 to 18, defendant numbers 19 and 20, and all proceedings initiated by the defendants in an attempt to execute the settlement agreement are a product of fraud, fabrication, collusion, and conspiracy, and should be delivered up and cancelled. My lord, one Honorable High Court has already held these are lawful. Then kindly see the next. Decree cancelling the settlement agreement dated so-and-so and the consequential issue transfer in favor of 19 and 20 as illegal, null and void. Now, my lord, this is again trying to overreach an order of an Honorable High Court. Now, my lord, kindly see. Upon cancellation, the transfer and then the perpetual injunction at K. Now, the interim relief is sought in terms of K. So, once your lordship is satisfied that they are fraudulent, then your lordship can consider perpetual injunction at the final stage, grant interim relief here. Now, my lord, their law imposes a bar under 23(3)(a). Now, kindly see 23(3)(a). A suit does not lie. Kindly see 3(a).
Yes.
No suit shall lie to set aside a decree on the ground that the compromise on which the decree is based was not lawful.
23.
3(a), please, my lord.
The suit must fail by the reason of formal.
Kindly see 3(a), 23(3)(a). Your lordship, I had shown your lordship 3. Now kindly see 3(a).
Yes.
No suit shall lie to set aside a decree on the ground that the compromise on which the decree is based was not lawful.
3A. 3A.
3(a). Now, I'm going to kindly see how the Supreme Court has interpreted this, because they will say we are third party. Here, your lordship sees 3(a) makes no distinction between parties to the suit and third parties. And this has now, my lord, been interpreted by the Supreme Court. Kindly see, my lord. ये दो ना और कॉपी इसका केशव होरी 2012 5 SCC 525. Kindly have, my lord. This appeal is directed against the judgment and order dated passed by the Allahabad High Court, by which it allowed the writ petition filed by R1 and R2, and you kindly see, set aside the order passed by the district judge, affirming the order of the Munsif, and held that the suit filed by the appellant was not maintainable, being barred in terms of Order 23(3)(a) of the Code. The appellant filed a suit in the court of Munsif seeking a declaration that the decree passed was fraudulent, inoperative, and not binding on him. According to the appellant, the defendants had instituted the suit before the assistant collector, in which his father, namely so-and-so, was made an order. In that suit, compromise petition, fake signature made. So the appellant was not party to that suit, and he says, my father's signature was forged, and my lord, fraudulent decree was obtained. It is a case of the appellant that no notice of the suit was ever served upon his father. He never appeared and was not even aware. He did not sign any compromise, where his alleged signature was fake. He died much earlier, was not even alleged. Kindly see, my lord, various reasons taken in paragraphs 3 and 4. Now, my lord, kindly come to paragraph 9. It is true.
Yes.
It is true that a compromise forming the basis of the decree can only be questioned before the same court that recorded the compromise, and a fresh suit for setting aside a compromise decree is expressly barred under Order 23, Rule 3A. It is equally true that the expression not lawful used in Order 23, 3A also covers a decree based on a fraudulent compromise. Hence, a challenge to a compromise decree on the ground that it was obtained by fraudulent means would also fall under the provisions of Order 23, Rule 3A. And then, Lordship kindly sees 12.
Yes.
So there is a now, my lord, on the facts of this case. Because it was not, this was before a revenue court and not the High Court. It was held that this suit is maintainable, that proceeding will not apply. So, my lord, this is, my lord, now, and it relies on another Supreme Court on this. So these reliefs, my lord, with the greatest of respect, cannot be entertained at this stage. A. B, my lord, on a prima facie case. Now, kindly see what the case before on the facts, which I don't think your lordship maybe would want to be troubled by, given the absolute bar in law. The agreement which they say was of 21st July 2014. That is, my lord, the deed of personal guarantee, which they say a clause of which has been infringed. That is the date. On that same date, my lord, a share pledge agreement was entered into on the very same date. Now, my lord, the share pledge agreement contained a list of shares which were pledged in favor of the banks on that day. On that day, these shares were in existence, but these shares were not pledged. Were not pledged. The shares of our respondent number 26, which are now stands to be transferred to me by virtue of the orders of the arbitration, settlement, and Delhi High Court, were not pledged. Kindly see the schedule once. So on the date of the share pledge agreement, the lenders were satisfied, my lord, that the securities which find mention in the share pledge agreement was satisfied, was sufficient. So on a test of prima facie case, your lordship will see whether if a party is satisfied with the guarantee and the specific pledge which is given to him on that date, whether he can seek to bring in other documents, and where do I stand, my lord, as a third party altogether. That is the case, my lord, today, which has to be satisfied. And without a satisfaction on prima facie case, my lord, balance of convenience, irreparable injury cannot be considered. Those are my statements.
Thank you. My lord, before my learned friend begins, no, not this. For note, and for your lordship. I am the only person who filed an application. Order 7, Rule 11, dismissal on other grounds. My case is mandatory just mediation. So this is and my lord, you should say, why is it so thick? Because I set out the paragraphs of the plain in the body. For instead of your lordship flipping these pages, I set it out.
Okay, thank you.
And that's all. I've given a copy to them.
Mr. Bose's, my lord, bounty, my lord, knows no limits. Now, my lord, I'll try to be very brief. My lord, has your lordship noticed one thing? My lord, 4 councils have how many? 4 na 5? 5 councils have addressed your lordships. Not one of them has tried to give your lordship a reason as to why, in spite of there being a specific bar under, my lord, both the guarantee agreement and the supplemental guarantee agreement, the shares were transferred. Not one word. My lord, what am I arguing? I am arguing fraud. The fraud vitiates everything.
Where the fraud was occurred?
When the fraud occurred. Not when the fraud occurred. When I came to know of the fraud. My lord, they are, my lord, arguing when the fraud occurred. I am arguing when I came to know of the fraud.
So you came to know, because that's why they have made out a case that as per your case, you have based upon the forensic report you came to.
My lord, may I just, yes. So
now they have made out, they argued the case that all the things of 2017 onwards ended in 2019. And they have based upon the arbitration award culminated to the settlement accepted by the High Court of Delhi. So that's why if it has been accepted by the Delhi High Court, how this court can interfere? This is the more or less.
Your lordship has, my lord, summed it up beautifully, my lord. May I try to address it? My lord, first, my lord, without addressing this question, my lord, I want to spend 1 minute, my lord, on, my lord, the point that I had started with, namely, my lord, one thing is undeniable, that, my lord, there has been a colossal and utter disregard of the contractual terms. And that is not disputed. There is no attempt to, my lord, even justify, my lord, why that was done. My lord, in Bengali, there is a word, besh korechi. That is, my lord, the explanation. I have done it, I have done it. So, the only defense is, you have come late. And therefore, whatever fraud I have committed since 2017 loses its significance. And you are not entitled now to any further protection by which, my lord, you are not entitled to any further protection by which the suit may ultimately, my lord, become, my lord, a piece of paper. my lord, a person of such antecedents who, my lord, have transferred, my lord, their shares worth crores of rupees. Two things. One is, my lord, there is no denial that no, this is not guarantee given by me. No, my signature on the guarantee is forged. No, it was obtained in a fabricated way. So, my lord, the existence of the deed of guarantee, the contents of the deed of guarantee, and the negative covenant contained therein is not denied. Number one. Number two is the fact that, my lord, the shares were transferred in spite of this negative covenant is also not denied.
Yeah, that is not denied.
So, my lord, today, my lord, if this is the antecedent of the party, let me go straight on the urgency. Now, my lord, today, assuming, my lord, today, my lord, I have a reasonable apprehension that they will again transfer it. I have now, my lord, initiated insolvency proceedings against them. Recently, before the NCLT, personal insolvency proceedings have been initiated. My lord, can I not come and ask now if my apprehension is that, my lord? Can I, my lord, I ask myself the question, my lord, assuming, my lord, I knew of something before, but the deed was already done. Is my learned friend saying, my lord, that, my lord, my cause of action is barred by limitation? He is not. He has not filed any application under Order 7, Rule 11, asking for rejection of my plaint because it is, my lord, ex facie barred by limitation. That I knew from F 17, 18, I did nothing, therefore I can't do anything any further. That's not the case. The case is only of revocation. So, my lord, with the utmost of respect, and I don't want to, my lord, again, my lord, read all the cases, my lord, on, my lord, section 12A. But, my lord, with due respect, my lord, even if I have, having regard to the conduct of this party, who is a habitual, my lord, person who transfers, my lord, in spite of, my lord, admitting to, my lord, negative covenant in the contract, my lord, it is, my lord, if I say that I have a justifiable, my lord, apprehension, which I have said, that the shares will again be transferred. So, my lord, what do? I file a suit against 27 people I have now filed against. So, again, my lord, that, my lord, after, my lord, 1 month will become suit against 35 people, then it will become against 75 people. So, this will go on. Multiplicity will go on.
Okay.
So, my lord, the first point on which I seek to, my lord, address your lordship is that since, my lord, there is not one word of explanation with regard to, my lord, this wrongful conduct of transfer, there is nothing to prevent them from doing it any further. And therefore, this apprehension is an apprehension which arises on a day-to-day basis. Every day I have a cause of action.
Yes.
That's my first point for your lordship's kind consideration.
Yes. Then
Now, my lord, let me take, my lord, the proverbial bull by the horn. My lord, what is their case? Their case is from 17, 18, I've been transferring, you've been doing nothing. My lord, like I briefly said, my lord, on the first day when I addressed your lordship, my lord, this is a personal guarantee. Now, my lord, when I give a when the bank accepts a personal guarantee, the bank makes an assessment of, my lord, the worth of the person giving a personal guarantee.
correct.
Because if the person has nothing, my lord, what is the point of taking his guarantee?
Yes.
But, my lord, in law, there is, my lord, no explicit charge in my favor in respect of those assets. So, my lord, there are certain known, my lord, methods of creating lien or charge or pledge. For example, if there's a mortgage, it has to come under section 58, my lord, of the Transfer Property Act. If there is hypothecation, my lord, it comes under securities. If there is pledge, my lord, a document has to be created under the Contract Act. So, my lord, in a personal guarantee, there is no, my lord, specific pledge of specific assets. My lord, this is the distinguishing feature. It is extremely important. So, my lord, one is expected not to, my lord, sell its assets. And in this particular case, my lord, there is an express bar to that effect.
Yes.
Now, my lord, if this is the bar, general bar, my lord, what do? Every, my lord, quarter, I'll tell them, give me stock statement of your clothes, your cars, your perfume, your handkerchief. Do I ask for that? I don't. There is no, my lord, I don't have the right to, my lord, ask them to go on giving me personal details of their personal net worth.
But you,
Now, my lord,
you being the bank, you had the authority to keep watch on that.
No, my lord, kindly, my lord, appreciate. My lord, why as a bank? My lord, I can, my lord, general by and large, my lord, of my lord, the assets which are specifically pledged to me. My lord, your lordship could have, my lord, perhaps, my lord, taken a view that, my lord, I should have been more vigilant. But, my lord, assets which are not, my lord, now today he says that he has transferred the shares of Sham Pharaoh. Sham Pharaoh is not my borrower. Sham Pharaoh is not my guarantor. Sham Pharaoh is not my borrower. My borrower is BRG Iron. Sham Pharaoh is not my borrower.
Okay.
Sham Pharaoh is not my guarantor. I have no right over the assets of Sham Pharaoh.
Okay.
I have not lent money to Sham Pharaoh that every day, my lord, I will go on inspecting, my lord, Sham Pharaoh's financials, or, my lord, inspect, my lord, Sham Pharaoh's, my lord, annual returns. I have nothing to do with Sham Pharaoh. It is only, my lord, instead of Sham Pharaoh, my lord, supposing he had given me a kitty. He had given me a kitty of, let's say, my lord, 40 companies, shares in 40 companies. So, my lord, my learned friend's argument is every morning I should have seen what is the annual return filed, what is the MGT 7 filed, my lord, in all these 40 companies. He could have given me a basket of shares to show his net worth. So, my lord, in law, my lord, with the utmost of respect, this sort of a dishonest plea that it was in the public domain. So many things, my lord, today, my lord, the shareholders of Reliance are in the public domain. Do I go to open every morning and see what is the shareholders of Reliance? I do not. So, my lord, in law, there is a legal obligation on him not to transfer the shares. Has he, my lord, shown your lordship, have any of them, out of the 27 defendants, have any one of them shown that the fact that they transferred the shares, they had the courtesy to inform me, and in spite of that, I did nothing? Any direct knowledge has, my lord, are they imputing that at any point of them, any of them, my lord, directly informed me and still I did not do any? I would have understood. But, my lord, I am to undertake investigation. And I am to undertake, my lord, then find out, my lord, so I have to proceed on the basis, my lord, that he will do this daylight dacoity under my nose. I have to proceed with that, my lord, apprehension. I won't do that.
Okay, you from the forensic report you got the information.
Yes.
File the suit very well. But with regard to you have narrated with regard to all the things with the award 34 and all.
My lord, I am coming to that. Give me, my lord, 2 minutes. I am coming to that. So, my lord, let me first take, my lord, Mr. Joyanto Mitra's submission. He, my lord, invited your lordship's attention to, my lord, paragraph 37 primarily. 1 or 2 other paragraphs also he showed. Primarily paragraph 37.
37.
My lord, what does paragraph 37 say, my lord?
37.
My lord, paragraph 37 is at page 38, bottom. My lord, this is, my lord, the situation as it stands today. Does it say one word about when I've come to know of the prevailing situation? That is there, my lord, where I have, my lord, stated about the forensic audit at paragraph 59. 59 to 68. My lord, let me read paragraph 37 because, my lord, I find that, my lord, today, my lord, Mr. Mitro will not decide in what order, my lord, I will state the chronology of my facts. If, my lord, paragraph 37 contains an admission that, my lord, these transfers which took place in 2017-2018, I knew about it from 2017-2018, then of course. Kindly, my lord, see, in order to defeat and defraud the plaintiff and each of them, in order to ensure that the said shares belonging could not be attached so and so or enforced, the defendants and each of them, including the plaintiffs, prior to admission of insolvency, to make it infructuous, the corporate guarantee so and so, and, my lord, then I've given the dates of transfer. My lord, where does it say, my lord, that I came to know of this transfer as on the date of the transfer?
No, that's why you have not mentioned about this, but you have mentioned about the forensic report. So where is your awareness when you came to know?
Yes, my lord. That is what the only thing that your lordship, my lord, has to consider today, respectfully, because that's my plaint, and he can't, my lord, ask, my lord, he can't seek to, my lord.
So where you pleaded that yes, it has been happened. Now you got the forensic.
My lord, kindly, my lord, have my plaint from, my lord, paragraph 60. My lord, kindly have it, my lord, from paragraph 60. Yes, 68. মানে give me 1 minute. ওটা কোথায় বললাম যে আমরা we anticipate that প্রথমে ইনসলভেন্সি কথাটা বলো। না, পার্সোনাল ইনসলভেন্সি ইনিশিয়েট করলাম সেটা আগে বলো। Give me half a minute, my lord. I want to start a little from before, my lord.
Paragraph 45.
My lord, kindly first start with paragraph 45, which your lordship will find, my lord, at page
of the plaint.
Of the plaint, my lord.
Is annexed to the revocation.
Yes.
Yes. My lord, kindly, my lord, let me lead, my lord, paragraph 45. From the resolution of dependent number 27 in insolvency, banks have recovered a total sum of 530 crores. As on date, a sum in excess of 29,000 is still due and owing to the banks. Accordingly, on or about July 2021, Central Bank of India, being plaintiff number 1, instituted personal insolvency proceedings against D1 to D4, inter alia under the provisions of Section 95 of the Insolvency Act. The said application was numbered so and so against so and so, so and so, so and so. Then, my lord, kindly come to the next paragraph. In connection with the CP number so and so, the Central Bank of India deemed it appropriate to make a forensic stroke special audit in the affairs of the D1 to D4 to assess and understand the scope and extent of the personal assets and net worth of D1 to D4. The auditor, Golcha Daga and Associates, carrying on business so and so, as aforesaid, so and so, furnished its report on 15th May 2025. Now, my lord, pause here for a moment. So, my lord, what is the sequence of events? Sequence of events is, my lord, I first initiated, my lord, insolvency proceedings against, my lord, our defendant number 27, which is the borrower. I recovered. After recovery, my lord, since that was grossly insufficient, I started, my lord, personal insolvency proceedings.
When that was recovery was made?
My lord, that recovery,
530
কোটি টাকা কখন recover করলে? My lord, I'm just finding the date, my lord. My lord, thereafter, my lord, I initiated personal recovery. Now, my lord, personal insolvency. Now, my lord, in personal insolvency, my lord, as your lordship, my lord, is so well aware, my lord, under the code, my lord, the process followed is this. My lord, once, my lord, a personal insolvency petition is filed, with the filing of the petition, my lord, there is an automatic moratorium that you cannot transfer. So, my lord, after this automatic moratorium comes into play, which is without any admission, immediately upon filing, my lord, an RP is appointed to give a report as to whether, my lord, personal insolvency, my lord, should lie or should not lie. He gives a report. After, my lord, after RP gives a report, my lord, it comes up for admission. And thereafter, my lord, parties can argue whether it's to be admitted or not. My lord, once it is admitted, my lord, then, my lord, the insolvency, the person against whom, my lord, this proceeding is started has to give a, my lord, a repayment plan. Now, my lord, that repayment plan which they gave, my lord, was a nil repayment plan. Virtually a nil repayment plan. And that,
kindly, my lord, have a look at 1378.
that repayment plan, my lord,
That's the call. 1378.
my lord, 1378. This is very important, my lord. I'm grateful to Mr. Ghosh.
volume 10, may I just take out? Volume 10 টা দিন আমি বার
Yes, yes, it is.
এখানে
কত টাকা বললো?
নীল নীল
হ্যাঁ।
কিছু নেই দিতে পারবে।
হ্যাঁ।
For such certificate, এরা কত টাকা? You can't decide.
Yes.
Now, my lord, at page 1378, kindly see. This is, my lord, Somkant Kushava and Company Chartered Accountants,
We have
To-
given this to them.
to whom it may concern. This is to submit that the net worth and assets. There are many such certificates, I'm showing. Of Anjani Kumar Goel. Anjani Kumar Goel, koto number defendant? He is, my lord, D1. Of Anjani Kumar Goel, son of so and so, Babu Ram Goel. Babu Ram Goel, my lord, is BRG. Son of, my lord, the founder of BRG, aged 75 years, so and so, so and so. Based on the document produced and explanation given to us. Now, my lord, kindly see details of immovable property in India. Kindly see, my lord, not applicable. Nothing is there. Then, my lord, next page. My lord, everything is not applicable. Then, my lord, cash in hand, my lord,
2 lakhs.
is, my lord,
2 lakhs.
2,47,000. My lord, princely amount of 2,47,000. On the basis of this, he guaranteed, my lord, credit facility is worth, my lord, about 5,000 crores.
Bank balance.
And, my lord, bank balance is even better, 1,90,000.
Amount investment, 400 টাকা আছে।
Then, my lord, kindly, my lord, scroll down.
This one shares belong.
My lord, just below this, amount invested in shares, amount government securities, nil. And shares, details of shares. এটা এখানে তো অনেক টাকা বলছে এখানে কি বলবো?
3.5. Then down to BRC.
3,59,000. My lord, details of shares are
59 lakhs.
3,59,007.
No, no, 3 crore 59 lakhs
3 crores.
7,120. 3 crore.
Just give me one moment. Will you? Yes.
Then to rename, life insurance.
Yes. So 3 crores 59 lakhs. My lord, your lordship is right.
There's a summary.
Then, my lord, kindly come to, my lord, the summary.
So, yeah, every-
My lord, kindly come to the summary at page 1381.
Yes.
My lord, your lordship will see, my lord,
Sir, this यहाँ से दिखाइए, so ये three-
Sandeep Goyal is undergoing a personal insolvency.
It is 0.
Ashok Kayan is there.
now, my lord, kindly, my lord, have page, I'm sorry, 1380.
80.
80.
My lord, one, my lord, kindly see 1380, where, my lord, at least something was there, my lord, 3 crore 59 lakhs being the value of shares. The fair value of the above investment of 3 crore 59 lakh 7,128 in companies has significantly eroded as these companies are under liquidation, stroke resolution process, stroke guarantors to company under liquidation. Shares are not traded on the stock exchange. Therefore, my lord, this entire value of 359 is in respect of stocks of, my lord, companies, my lord, which are, my lord, virtually in liquidation, zero, nil value.
Correct.
So, my lord, Anjani Kumar Goel, son of Babu Ram Goel, founder of BRG Iron, has, my lord, given his personal, my lord, guarantee for, my lord, about a limit of 5,000 crores, and today he is penniless. All that he's done is, my lord, he
No, sir, there are 3 more certificates also rather than. If they have to.
and, my lord, this, my lord, is very important. The date is very important.
20th March 2020.
20th March 2024. This is when, my lord, the alarm bells start ringing. This is when the alarm bells start ringing.
Yes.
Jewelry nil, money nil, everything nil, property is nil, nothing they have.
Yes.
So, my lord, there are, my lord, as your lordship knows, my lord, the original personal guarantors are R1 to R4. Similar, my lord, in respect of each of them. The next, my lord, the next one, my lord, is at page 1388. This is, my lord, Himanshu Goel. That is, my lord, the grandson of Babulam Goel,
Yes.
Anjani's son. He is also, my lord, all nil, nil, nil. Everything is nil. My lord, at page 1389, his cash in hand is 1,09,000 and bank balance is 4,39,000. Little better than his father's. And my lord, the value of the shares is 3 crore 81 lakhs, 84 lakhs. Again, my lord, the fair value of 3 crore 84 lakhs has significantly eroded. Companies are under liquidation. So they have nothing in their name. So, my lord, four such, my lord, certificates, my lord, have been furnished by their chartered accountants. These are, my lord, their documents. The next one, my lord, is at page 1398. This is, my lord, Sandeep Goel, son of Anjani, is the second son of, my lord, Anjani, second grandson, my lord, of Babu Ram Goel. My lord, his bank balance is little better. He's got 7,94,000 in the bank. And, my lord, he has, my lord, shares worth, my lord, of 9 crore 7 lakh. These also fair value, my lord, is significantly eroded. We don't know, my lord, what the fair value today is. All, my lord, on the same date.
Personal guarantee proceedings say this is the repayment plan.
Yes.
And, my lord, the last one is at page 1407. This is of Jay Kumar Goel. He is also, my lord, he is son of Baburam Goel. So he is brother of Anjani. So, my lord, altogether, my lord, on 20th March 2024, my lord, we got this repayment plan, which showed, my lord, that their assets were nil. This is when the alarm bell started ringing. This is when we appointed Golcha and Company. So, my lord, respectfully, my lord, the relevant date is not when they perpetrated the fraud. The relevant date is when I came to know of the fraud.
Certificate দিয়ে বলছে নেই তার আগে আমি আসবো
So, my lord, your lordship will kindly see, my lord, there is not, my lord, neither in law nor, my lord, in practice. My lord, our, my lord, personal guarantors, my lord, ever called upon, my lord, every, my lord, bank keeps, my lord, a strict check on, my lord, which car he sold when, which car he's purchased, what. My lord, this is not like stock statement. There is no hypothecation of personal assets. My lord, if there is stock statement, one has to give periodical stock statement. Personal guarantees don't give, my lord, any periodical statement.
How much time will take, Mr. Shah? Because other fixed matter is there.
My lord, just give me 5 more minutes, I'll conclude. 5 minutes, I'll conclude, my lord. There's not much to it. Now, my lord, moving on quickly. We are at the ad interim stage. Now, my lord, so far as, my lord, Mr. Mukherjee's submission is concerned, my lord, I'll run through it very quickly. My lord, so far as Mr. Mukherjee's submission is concerned, first, my lord, kindly note he appears for 16 to 18.
Correct.
He has not filed, my lord, the revocation petition. So, my lord, these questions of urgency, whether it is there or not there, it is not for him to argue. So, he can only argue, my lord, why, my lord, there should not be an injunction.
Who is Mr. Joyant? Who is Mr. Ramos?
So, my lord, 16 to 18, 16 to 18, my lord, are the companies, my lord, to which R5 to R15 have transferred the shares. R5 to R15, my lord, have transferred their shares to 6 to 18. Neither is there any letter at any point in time by R5 to R15 saying, my lord, these corporate guarantors are transferring their shares. Nor, my lord, has 16 to 18 ever, my lord, made it clear that they have received these shares. Now, my lord, does, my lord, 16 to 18 did not conduct any due diligence before, my lord, buying these shares or taking whichever form is the form of transfer. They didn't know, my lord, personal guarantees were given by these persons. Then, my lord, on the contrary, the due diligence or the failure thereof, my lord, is on their part. On the part of Mr. Mukherjee's clients, 16 to 18, they have accepted shares of, my lord, a person who has given, my lord, a personal guarantee. And against whom, my lord, proceedings, my lord, the proceedings against the company had already been initiated. So, my lord, the failure to do proper diligence is on their part. They should have informed, my lord, the banks. They did not inform the banks. So, my lord, they are, my lord, running a case that, my lord, they should be allowed to benefit, my lord, because of their own wrongdoing.
Yes. এই জন্যই ওকে appeal court সবাইকে
appeal court order টা আসছে। So, my lord, that 1 minute here, এত তো বলতে হবে, it's running short of time. Now, my lord, kindly see. So, my lord, Mr. Mukherjee, my lord, each of his prayers that, my lord, I uploaded on this day. This is the day when these uploadings, he is not uploaded. Sham Pharaoh has uploaded.
So that's why their contention is that it was uploaded. It is
in the public domain.
So we
In the public domain. So I should automatically have had knowledge.
had the knowledge, but you have taken.
And, my lord, while making this, my lord, argument, which, my lord, has no basis in law, not supported, my lord, by any section of any statute, that, my lord, from time to time, my lord, I have to check, my lord, the assets of the personal guarantor. My lord, he has, my lord, also not stated, my lord, that, my lord, he has ever informed, my lord, that, my lord, the shares had been transferred. And, my lord, I've already, my lord, I don't want to repeat, Sham Pharaoh has nothing to do with me. I'm not going to get up every morning, my lord, and check, my lord, who are its shareholders.
Yes.
These companies, such large companies, my lord, huge body of shareholders, all public limited companies. I'm going to sit and check, my lord, who are the shareholders.
Yes.
Then, my lord, my learned friend says that, my lord, the forensic report. Now, my lord, these are, my lord, first principles, my lord. My lord, I filed a plaint. You have to go, my lord, the statements contained in the plaint. My lord, your lordships usually follow a practice that, my lord, in Order 7, Rule 11 applications, you all don't even permit the filing of an affidavit in opposition. Because, my lord, the plaint will, my lord, stand or fall on the basis of the pleadings in the plaint, not what they say in the opposition. So, my lord, all these submissions, my lord, if I have said that, my lord, I came to know that you became, your net worth became nil in 2024 March. Thereafter appointed an auditor. Auditor gave a report on 25th May. I am immediately come to court. Yes. Then, my lord, that statement made in the plaint is not open to challenge at the time of, my lord, saying that, my lord, leave under 12 years should be done away with.
Suppression, what is suppression? I've annexed it.
Then, my lord, your lordship, my lord, will kindly see the next point, my lord, that has been taken is, my lord, 2 points I'll just address your lordship on settlement and, my lord, on the Delhi High Court order and the order, my lord, of the Calcutta High Court. Now, my lord, kindly see. Before that, my lord, both Mr. Joyanto Mitra, who appears for 5 to 15, and, my lord, Mr. Ramanujan, who appears for 19 and 20. Ramanujan appears for 21 to 25, and Thakkar, my lord, who 19 to 20. My lord, Mr. Joyanto Mitra and Mr. Thakkar, they appear, my lord, for 5 to 15 and for 19 to 20. I am not asking for injunction against them because they have already divested the shares. I am saying, my lord, whoever has the shares now, my injunction is only against 21 to 25 and against 16 to 18, who are the present shareholders.
No injunction against?
My lord, I am only seeking injunction against 21 to 25, who are the wives who have been transferred 4% share, and against 16 to 18, who are, my lord, 2 companies who have received, my lord, the corporate shareholding of from 5 to 15 of 38%.
Yes.
That's my case. So, my lord, I really don't see, my lord, how, my lord, Mr. Mitra or Mr. Thakkar, my lord, can really have, my lord, any objection, my lord, to my petition. Now, my lord, coming to, my lord, these 2 things. First of all, my lord, kindly take, my lord, Justice I.P. Mukherjee's order. After this, my lord, I will say, my lord, kindly just pass an order in terms of this order. Because Mr. Ramanujan, my lord, who represents, my lord, 21 to 25 is citing this order. My lord, this order, which is of DB of our court, is, my lord, between the members of the Goel family. Your lordship will not find from the cause title. Now, my lord, kindly come to, my lord, paragraph, the operating portion of this order.
Page 4, last paragraph. Page 4, last paragraph, considering all the above circumstances.
Yes, my lord, considering all the above circumstances, we are of the view that these applications should be heard on affidavits by the single judge as soon as possible. The interim period, we restrain the parties from altering the status quo with regard to holding and dealing shares by the family companies. Furthermore, we restrain the respondents from making any use of the funds received. So, my lord, your lordship has seen, my friend has already said that D21 to D25 are parties to this matter. So automatically there's an order of restraint. The wives can't transfer or deal with the shares anymore.
Yes.
We were unaware of this order. But, my lord, this is an order, my lord, which, my lord, already, my lord, I'm so grateful to my learned friend. Because, my lord, already, my lord, so, my lord, 2 concessions he makes. He says, my lord, D21 to D25, against whom I'm asking for orders of injunction, are parties, my lord, to this appeal.
Correct.
And there's already, my lord, a pending order. So, my lord, this, my lord, further order, my lord, they can't, my lord, possibly object. That's my first, my lord, submission with regard to Justice I.P. Mukherjee's order, DB order. Second, my lord, is, my lord, the settlement. My lord, the Delhi High Court order. Give me the Delhi High Court order. The Delhi High Court order, my lord, merely records the settlement. Nothing else. The Delhi High Court order, my lord, merely records the settlement. Kindly see the Delhi High Court order.
Paragraph 6.
I have perused terms and consider. I find the same to be lawful. Undertaking given to court or accepted petitions. My lord, what does that? My lord, trying to set one court against the other. My lord, what does it do? Delhi High Court parties have received a settlement. The court shall record the settlement between the parties. Delhi High, how is it, my lord, setting? Did Delhi High Court consider, my lord, what is the settlement, what is not the settlement, my lord? My lord, I am, my lord, completely, my lord, bewildered that, my lord, this submission could be made that, my lord, I am trying to set one court against the other. You entered into a fraudulent settlement. That, my lord, the Delhi High Court was not examining at that point in time. All the parties came and said, this is the settlement.
But they have prayed that settlement you have relied upon in this app.
My lord, I am not asking for setting aside of that settlement at all.
That's why they have stated that you have relied upon this and you have disclosed the settlement agreement. The settlement agreement in terms of the section 34 and the Delhi court has accepted the settlement agreement.
Yes.
Whether now you can say that this is a fraud once the court has accepted. If it is a fraud and you are agreed, then they are that you have.
Yes, my lord, may I answer this question? My lord, Delhi High Court has only recorded a settlement.
Correct.
It is real, my lord, there is no application of mind. There is no going into, my lord, the terms of settlement. Nothing. Delhi High Court has recorded a settlement. So, my lord, if upon an examination of the facts of the present case, your lordship finds that, my lord, Delhi High Court, my lord, has restrained the banks, or the banks, my lord, can be restrained on the basis, my lord, first of all, my lord, banks are not a party to this Delhi High Court proceeding. So how is it, how are the banks bound by it? You go and file a fraudulent suit, obtain a settlement, and then you throw it at my face. I'm not a party to this proceeding. So, my lord, my first submission, my lord, with 2 submissions, my lord, with regard to, my lord, Delhi High Court order. Number 1, banks are not a party. Number 2, you've never even intimated the banks about this Delhi High Court proceeding. And number 3, my lord, is that, my lord, this is merely recording a settlement. Now, my lord, kindly, my lord, take the Supreme Court judgment, my lord, which my friend, my lord, cited, saying that, my lord, under, my lord, Order 23, Rule 3A, my lord, a settlement cannot be challenged, my lord, by way of a separate suit. My lord, that is, my lord, 2012 5 SCC 525. Kindly, my lord, have the, my lord, have it, my lord, from paragraph 9. We show or they show 9?
They should. And they will stop.
1 minute. My lord, kindly have paragraph 9, which is what they showed. It is true that a compromise forming the basis of a decree can only be questioned before the same court that recorded the compromise, and a fresh suit for setting aside the compromise is expressly barred by Order 23 Rule 3A. It is equally true that the expression not lawful used in Order 23 Rule 3A also covers a decree based on fraudulent compromise. Hence, a challenge to a compromise decree on the ground that it was obtained by fraudulent means would also fall under the provisions of 23 Rule 3A. Then, my lord, kindly have paragraph 16. It is also well settled that under section 9 of the CPC, civil court has inherent jurisdiction to try all types of civil disputes, unless its jurisdiction is barred expressly or by necessary implication by an authority, by a statutory provision, and conferred on any tribunal or other authority. We find nothing in Order 23 Rule 3A to bar the institution of a suit before the civil court, even in regard to decrees and orders passed in suits or proceedings under different statutes before a court, tribunal, or authority limited and authority of limited and restricted jurisdiction. In our view, in the facts of the case, provisions of Order 23 shall not act as a bar against the suit filed by the appellant. We accordingly set aside the order of the High Court. As a consequence, the suit will be restored before the Munsif, who is directed to accord priority. So it can proceed.
Yes.
This is the Supreme Court, my lord. This is the conclusion.
Yes.
Now, my lord, 2 minutes, my lord, on the settlement, and then I am done. So, my lord, the decision of the Honorable Supreme Court, my lord, I am grateful to my lord, Mr. Thakkar, for it, my lord. It's, my lord, completely in my favor. Lastly, my lord, the settlement. Where's the settlement?
We see paragraph 12 once of the decision. Passed by a revenue court, not a civil court.
Now, my lord, kindly see. Kindly see, my lord. And my lord, the principal issue, my lord, which I am arguing is that, my lord, there is no prayer in my suit for setting aside that settlement. I am not asking for that settlement to be set aside.
Yes.
That settlement, my lord, is between two parties fraudulently made between each other, my lord. Both, my lord, I have shown your lordship already, completely, my lord, owned by the Goel family. My lord, these are, my lord, your lordships, my lord, are the highest court in the land. Your lordship will have to, my lord, with the utmost of respect, my lord, notice these facts. So, my lord, so far as the settlement is concerned, my lord, what happened? My lord, first of all, there was an award. My lord, in the award, my lord, they came, my lord, and they said, my lord, that the award will be nullified, my lord, by transfer of these shares. And they transferred it to the award, my lord, from their own company, settled, my lord, by transferring this. My lord, so, my lord, it becomes difficult, my lord, to transfer, my lord, shares of, my lord, hundreds and hundreds of crores, my lord, without anything. So they create a fictitious arbitration. There's an award, and that award, my lord, is settled by way of, my lord, mediation, my lord. And, my lord, what is the settlement? That your company will become, my company will become your company, and, my lord, the company is transferred, my lord, to, my lord, 19 and 20, who are, my lord, based outside. My lord, these your lordship will go into, my lord, whether there's a fraud, to what extent there is a fraud. This is not an application under Order 7, Rule 11. And this is also, my lord, not, my lord, for prima facie, my lord, it doesn't impinge on, my lord, on the maintainability of the suit. So today, my lord, the only question is, my lord, based on, my lord, the 3 golden principles of granting injunctions, my lord, kindly see the balance of convenience. Whether I've made out a prima facie case. And, my lord, if these shares are further transferred, my lord, this is the fundamental question which my friends should have answered. If the shares are further transferred, my lord, then, my lord, what am I left with? Who am I going to fight against?
Yes.
My lord, these are my respects.
Thank you.
I'm very grateful.
Thank you.
So your lordship requires a small note within a day or two.
But only just give me 1 minute.
No, my lord, no minutes, my lord. There's no reply to reply.
2 minutes.
No,
But a false statement has been made by
already I have
Grateful.
They will kindly keep it on tomorrow,
no.
day after any.
Okay, after vacation, interim order.
1 minute, right? Just take 1
I am passing an interim order after vacation. If you wanted to argue the matter further.
Not argue. Just what
For 2 months, 2 hours, I have taken. You have taken the time. Again, you wanted to reply the same.
not reply.
Then
one paragraph I'll show
nothing.
for my application. Paragraph 8 of my application.
Already shown what you have shown in the.
Five people have argued on their behalf. Again, my lord.
There is no answer that when the loan will be paid back. There is no answer.
My lord, may I file a short note, my lord, by Monday? Monday. I am grateful.
All party filed. All party.
We have already filed.
On Monday, my lord. I will. Grateful. Deeply obliged.
Revocation এ করেছো ভাই।
It's only in respect of my application.
But
Application for revocation, that note I have filed.
the counsel for the respective parties have concluded their arguments in regard to the revocation of the leave
Everything.
and validity of parties are directed to file their written notes of argument. Written notes of argument by 22nd of September 2025. Leave the matter on 22nd September and under the heading to be mentioned only for filing written notes of argument by the party.
Great.
ठीक है?
Affidavit of the Postal.
Yes.
When का जो report था वो कहाँ पे एक बार
हाँ.
दिखा दो।
हाँ.
ये वाला ना? के लास्ट में है ना?
Innocent error in the affidavit regarding the dates. Paragraph cannot take note of that affidavit one.
Where is the affidavit?
But kindly take note of directly paragraph 5 at page 4. Prior to that, I have indicated when I have retired and etc. Paragraph 5 in the circumstances I have indicated. Well, kindly turn to subparagraph C. It is mentioned by 31st, it will be August 31st. I'm sorry. Well, that error could not be rectified in my lord's copy because it was already affirmed and I noticed.
Is it August?
August, and the next, my lord, the annexure, it will be August also. In present paper, it will be August.
Which?
My lord, the annexure to subparagraph C, my lord, there is mentioned photocopy of the memo.
Achha.
Yes, my lord, it was mentioned dated February 5. It will be also August.
August.
कहाँ पे February 5 कहाँ पे?
August. No,
August
August
5.
31 or August 5.
No, দুটোই August হবে sir.
No.
একটা 31
That is the
5.
first, you are telling that the August 31st.
31st, I was made aware by the police when they visited my residence with the circulation, my lord, with the notice. that
You 35 5th August you retired.
No, my lord. 5th August is the date of notice issued on behalf of the Honorable High Court. My lord will see that in page 19, 19. The date is mentioned
5th August.
inside the memo. It is 5th August. I'm extremely sorry for this, my lord.
Okay.
You have to correct
Yes.
it.
My lord, I'm
Corrected. I will.
I'm grateful.
Yes. You will examine.
Yes, sir.
बैठ जाए ना
Please doctor na.
বলুন, আমি শপথপূর্বক বলছি,
আমি শপথপূর্বক বলছি,
এই মামলায় সাক্ষ্য দিতে এসে
এই মামলার সাক্ষ্য দিতে এসে
আমি যা বলবো সত্য বলবো,
যা বলবো সত্য বলবো,
সত্য বই মিথ্যে বলবো না,
সত্য বই মিথ্যা বলবো না,
কোনো কথা গোপন করব না।
কোনো কথা গোপন করবো না।
আপনার নাম?
মনোজ কান্তি দত্ত।
মনোজ কান্তি দত্ত। বানানটা বলতে পারবেন ইংরেজিতে?
MANOJ
MANOJ
KANTI
KANTI
DOTTA।
বাবার নাম?
ফাদার্স নেম নেপাল চন্দ্র দত্ত।
নেপাল চন্দ্র দত্ত, তাড়াহুড়ো করবেন না, একটু স্পষ্ট উচ্চারণে বলুন। বলতে হবে না। আপনার বয়স?
58।
58। কি করেন আপনি?
আমি রিটায়ার্ড পার্সন। রিটায়ার্ড
পারসন।
সেন্ট্রাল গভর্নমেন্ট এমপ্লয়ি, রিটায়ার্ড পার্সন।
সেন্ট্রাল গভর্নমেন্ট, এক্স সেন্ট্রাল গভর্নমেন্ট এমপ্লয়ি করে দাও। বাড়ির ঠিকানা বলুন।
বাড়ির ঠিকানা মাদ্রাল বকুলতলা।
বকুলতলা?
মাদ্রাল MADRAL মাদ্রাল।
মাদ্রাল বকুলতলা।
পোস্ট অফিস মাদ্রাল।
পোস্ট অফিস মাদ্রাল।
পিন 7431
7431
26। হ্যাঁ, ওটা যে মাদ্রাল ভায়া কাকিনাড়া হবে, মানে আমাদের ব্রাঞ্চ অফিস তো।
ঠিক 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 স্যার।
Yes, continue.
Mr. Dotto,
হ্যাঁ।
From which period you were attached to this Noihati sub post office?
নৈহাটি সাব পোস্ট অফিসে আপনি কোন সময়কালটাতে জড়িত ছিলেন? কোন সময় থেকে কোন সময় পর্যন্ত সেটা বলুন।
আমি 1917 থেকে রিটায়ার করেছি 2024 ফার্স্ট, মানে 31 মার্চ, এই 1/3/2024 রিটায়ার করেছি।
1917 সালটা বলুন।
17 হচ্ছে
কোনটা সাল?
মানে 1917 ওখানে জয়েন করেছি।
1917 পসিবল এটা? 1917 সালে?
সরি,
Cannot be. Can be 1970.
হ্যাঁ 2017
থেকে আপনি 2024 সাল পর্যন্ত ছিলেন।
Little nervous.
I was there from 2017
He will be there, we also nervous.
Yes, yes, Your Lordship.
2024.
Absolutely, absolutely.
From the year 2017 to 2024.
The environment is like this. Cannot be.
তুমি আবার হ্যাঁ করছো।
তো আপনি 2017 থেকে till your retirement
2017 থেকে
in 1st March 2024 আপনি নয়াটি সাব পোস্ট অফিসের সঙ্গে যুক্ত ছিলেন। So, you were attached to নয়াটি সাব পোস্ট অফিস from 2017 till 1st March 2024. Now, in Nohati sub post office, there was several beats.
Yes.
Now, this particular area, Kathalpara, in this beat, how long you were there?
কাঁঠালপাড়া বিটটাতে আপনি কতদিন ছিলেন?
During the joining, I was totally.
আপনি বাংলায় বলুন, উনি ট্রান্সলেট করে দেবেন।
যখন আমি জয়েন করেছি তখন থেকে আমি ওই বিটে ছিলাম।
Since my joining, I was joining.
Since my joining till my retirement, I was in the same beat.
I was in the same beat, namely Kathalpara. Namely Kathalpara.
You must be aware of the area of Kathalpara.
Yes.
Yes.
Now, are you aware there is a jute mill? There used to be a jute mill called Nodia Jute Mills in Kathalpara area.
Yes.
Now, this Nohati jute.
Just a minute.
Oh, sorry. Oh, I'm sorry.
Yes, continue.
Now, this Nodia jute mill is a big chunk of land. Yes.
Yes.
There are two roads on the two sides of this jute mill.
জুট মিলে দুদিকে দুটো রাস্তা আছে, ঠিক?
What are these two roads?
Two roads.
রাস্তা দুটোর নাম কি কি বলতে পারবেন?
ওই একটা হচ্ছে কাঁঠালপাড়া রোড।
One of them is Kathalpara Road and the another is
নৈহাটি মেইন রোড।
and the another is Noihati Main Road.
Do you mean Ghoshpara Road?
নৈহাটি মেইন রোড বলতে কি আপনি ঘোষপাড়া রোড বলছেন?
নৈহাটি ওইটা কাঁঠালপাড়া রোড। ঘোষপাড়া রোডটা আমাদের ভাটপাড়া পড়ছে, ভাটপাড়া এরিয়া।
No, ask whether this main road what is telling, that is called as a Ghospara road or not?
মেইন রোডটা কি ঘোষপাড়া রোড?
না।
No.
Mr. Dotto, are you aware that in that Nodia jute mills area, several companies are functioning?
আপনি কি জানেন যে নদিয়া জুট মিল এরিয়াতে অনেক কোম্পানি কাজ করছে? No.
আমি তো পোস্টাল ডিপার্টমেন্টে আমি অত এই ব্যাপার জানি না।
I belong to the postal.
Have you
department.
delivered?
Sir, one
Oh.
minute. I belong to the postal department, so I do not have
Any such
knowledge
idea?
about these things.
You must have delivered letters to various companies in that Guwahati jute mill compound.
Whenever I'm giving any letters, seal and stamps will be given to them. Otherwise, I cannot deliver any articles. Seal must be given whenever they receive the letter.
Very
When a letter is to be delivered to the addressee, I used to deliver the letter by handing over to the addressee by taking the seal and signature and the stamp of the addressee.
I'm suggesting to you that on two sides of this Nodia jute mill, there are two roads. One in the side is called the Kathalpara road and the main road is Ghoshpara road.
উনি আপনাকে সাজেশন দিচ্ছেন যে নদিয়া জুট মিলের দিকে দুটো রাস্তা আছে, একটা হচ্ছে কাঁঠালপাড়া রোড আর একটা হচ্ছে ঘোষপাড়া রোড।
ঘোষপাড়া রোড
আপনি বলুন ওনার বক্তব্যের সাথে আপনি কি সহমত?
ঘোষপাড়া রোডটা আমাদের এরিয়া না না না
আই ডিসএগ্রি। এবার বলুন।
আমাদের ঘোষপাড়াটা হচ্ছে আলাদা অফিস, ওটা ভাটপাড়া এরিয়া পড়ে যাচ্ছে। আমাদের এরিয়াটা পড়ছে ওই নৈহাটি আপনার কাঁঠালপাড়া।
Ghoshpara road is
another road which belongs to the Bhatpara, where our office belongs, right? আপনাদের অফিসটা যেখানে আছে, our office is situated করে দাও বা located. Our post office is located.
The junction of Kathalpara road and Ghoshpara road, is it called Nodia Mill More?
ঘোষপাড়া রোড এবং কাঁঠালপাড়া রোড এই দুটো যেখানে মিলিত হয়েছে এটা কি
Nodia Mill More?
মিল আন্ডার কাঁঠালপাড়া 77 কাঁঠালপাড়া
বলে হ্যাঁ বা না? ইয়েস।
না আমাদের না, ওটা পড়ছে, ওটা আমাদের কাঁঠালপাড়াটাই পড়ছে, ঘোষপাড়াটা পড়ছে।
আপনাকে জিজ্ঞেস করা হচ্ছে কাঁঠালপাড়া রোড এবং ঘোষপাড়া রোডটা যে জায়গায় মিলিত হচ্ছে ওটাকে কি নদিয়া মিল মোড় বলে?
হ্যাঁ,
ইয়েস।
লেফট সাইড ঘোষপাড়া, রাইট সাইড হচ্ছে কাঁঠালপাড়া। ওটা আন্ডার মানে অ্যানাদার পোস্ট অফিস ভাটপাড়া।
আস্তে আস্তে বলুন স্যার, আরেকবার বলুন কি বললেন।
যেটা
রাইট সাইডে
ঘোষপাড়াটা পড়ছে ভাটপাড়া আন্ডারে,
ঘোষপাড়া ইজ আন্ডার ভাটপাড়া,
আর নৈহাটি পড়ছে কাঁঠালপাড়া মেইন রোড, নৈহাটি মেইন রোড।
and the Noihati main road
ওইগুলো নৈহাটি আন্ডার পড়ছে,
is under Noihati.
Is there a wooden bridge at Nodia Mill More?
নদিয়া মিল মোড়ে কি কোনো কাঠের ব্রিজ আছে?
অপোজিট সাইড।
নদিয়া মিল মোড়ে কি কোনো কাঠের ব্রিজ আছে? হ্যাঁ না না?
নদিয়া মিলে কোনো কাঠের মিল নেই, অপোজিট সাইডে আছে।
On the opposite side of the jute mill there is a wooden bridge. তাড়াহুড়ো করবেন না, আস্তে আস্তে ভেবেচিন্তে উত্তর দিন।
Can you tell my lord the difference between delivering an envelope and delivering an envelope with AD card?
এনভেলপ ডেলিভার করা একটা এনভেলপ উইথ এডি কার্ড ডেলিভার করার মধ্যে পার্থক্য কি বলতে পারবেন?
ওতে যে এডি কার্ড হচ্ছে অ্যাকনলেজমেন্ট, ওর সাথে অ্যাটাচ থাকে।
এডি কার্ড ইজ an acknowledgement which is attached with the envelope.
Envelope, হ্যাঁ,
right?
অ্যাটাচ থাকে।
Is it your duty to get this AD card signed by the recipient?
Yes. Yes. Recipient will also seal and stamp and signature. Everything will be given.
At the time of receiving the letter, the recipient has to sign on it and affix the stamp or seal of the company.
এরকম একটা ব্রাঞ্চ ডেপুটি শেরিফের অফিস থেকে এসেছে।
ওনাকে বলুন স্যার।
এরকম একটা ব্রাঞ্চ ডেপুটি শেরিফের অফিস থেকে এসেছে।
वही तो हम आपसे पूछा कहाँ है वो, आप पूरा उठा के सर्विस का नोटिस दिया।
हाँ हाँ
अरे पूरा रेट ऑफ समन्स का फाइल होता ना, वो कहाँ है?
অফিস থেকে এসেছিল এখানে আছে
नहीं, पूरा रेट ऑफ समन्स का फाइल था, वो नहीं है। ये तो हमारा ऑर्डर शीट।
आप लोग सप्लीमेंट्री बनाएंगे, नहीं बनाया अच्छा रहता ना।
हमने सप्लीमेंट्री बनाया, एडिशनल भी बनाया, एडिशनल रेट भी बनाया।
2025
বোঝার জন্য না
এর আগে দুদিন ধরে প্রশ্ন জিজ্ঞেস করা হলো না। হ্যাঁ 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 এই
We have given the additional judges brief. This is attached.
We had a road work.
একটু দেবেন पेज ही लेते
हम उन लोग को सर्व किए थे ना एडिशनल जजेस की।
कंप्लीट ना दिस इज नॉट कंप्लीट नो 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 दिस इज नॉट कंप्लीट
পেজ নাম্বার 11
না 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 इसके बाद পরে আরেকটা এসেছে এটা পরে আরেকটা এসেছে দেখুন এই যে যাতে এই ধরনের ডকুমেন্ট আছে
এডিশনাল ব্রিফ অ্যাটাচ আছে
एडिशनल আমাদের एडिशनल जजेस brief আছে। हम सर एडिशनल जजेस brief उसमें लगा हुआ है सब।
কপি দিতে পারি তাহলে তো
না না আমরা আপনাদেরকেও সার্ভ করেছি জাজ করে।
হ্যাঁ হ্যাঁ হবে
अरे इस तरह ना पूरा एक पूरा सेट था, उनको दिया तो उन्होंने गैरस करे हैं।
एडिशनल
पूरा सेट आया तो वहाँ यहाँ से रिपीट इस तरह पूरा सेट हो गया। देखो
গত দুদিন on that basis examination was done
एग्जिबिट्स का कोई डॉक्यूमेंट्स है?
দেখুন ফার্স্ট পেজটা এরকম থাকবে
हाँ
ये हो रहा है ना।
Mr. Dotto, I am showing you a document. Oh, अच्छा पेजটা বার করুন This is also not the bunch. আমি এতগুলো ফাইল কি করে হয়ে গেল So Dotto, I am showing you a document dated 30th December 2024 signed by in charge CB from the office of Director Kolkata GPO. Do you agree with the contents of this letter?
এই ডকুমেন্টে যা লেখা আছে তার সঙ্গে কি আপনার সহমত? পড়ে নিন, অসুবিধা হলে বলুন, আমি বলে দিচ্ছি।
Yes,
I agree.
because delivered on 29 instead of 11 মানে নভেম্বরে হয়নি, এটা
এটা-
সেপ্টেম্বরে হয়েছে।
এখানে যা লেখা আছে আপনি তার সাথে সহমত তো? ইয়েস, আই এগ্রি।
No. Mr. Dotto, do you know a company called Gajmukh Binimoy Private Limited?
কাজমুখ বিনিময় প্রাইভেট লিমিটেড বলে
হ্যাঁ,
কোন
আছে দুটো কোম্পানি একই ডিপার্টমেন্টে, দুটো
Yes.
কোম্পানি আছে, গজমুখ এন্ড জয়জুট।
স্যার আস্তে আস্তে
গজমুখ জয়জুট দুটো কোম্পানি আছে।
স্যার একটা একটা করে সেন্টেন্স বলুন।
হ্যাঁ।
আছে, ইয়েস আই নো কোম্পানি নেম কি কাজমুখ।
মাইকটা অন নেই, মাইকটা অন করে দিন না, শোনা যাচ্ছে না মাইক
কাজমুখ কি
গজমুখ ইন্ডাস্ট্রিজ
ইন্ডাস্ট্রিজ। এবার বলুন, আস্তে আস্তে বলুন স্যার।
and another জয়জুট ইন্ডাস্ট্রিজ,
and another company namely Joyjut Industries.
two companies are
দুটো কোম্পানি সেম কম্পাউন্ড।
same company.
both the companies are at the same compound. আস্তে আস্তে বলুন স্যার।
Are there any other companies in the same compound?
No,
No,
no other companies.
no
Only
other
two companies.
no other company is there in the same compound.
These two companies have their separate gates.
দুটো কোম্পানি কি আলাদা আলাদা গেট আছে ঢোকার?
No, same gate, same
Both the companies
same
have the-
person receiving letters.
উনি জিজ্ঞেস করছেন
হ্যাঁ।
ঢোকার গেট কি না আলাদা?
একটা হচ্ছে গাড়ি যাচ্ছে, একটা রোড আছে, আর একটা পাশে একটা আছে, ওটা দিয়ে লেবারে যাচ্ছে। হ্যাঁ, এটা হচ্ছে গাড়ি আছে একটা, আর একটা হচ্ছে লেবারে যাচ্ছে। দুটো গেট আছে।
দুটো গেট আছে। There are two different gates. From one gate
আর একটা আছে লেবারদের জন্য।
and out.
দুটো গেট আছে।
Yes, what? Repeat the answer. How many gates are there?
Two gates, sir.
There are two gates.
Two gates.
Both gates are used for the entrance and exit. Both.
Yes, হ্যাঁ। এন্ট্রান্স আছে, দুটোতেই আছে এন্ট্রান্স, মানে যাচ্ছে আসছে লোকজন লেবাররা।
Both can from the both gate both can be anybody can be entered.
Anybody can enter.
Anybody can enter from the both gates.
He also said there is one receiving officer. He said there is one receiving officer. He also said one receiving office person who receives letter for both.
There is what is the answer given?
Follow.
You said there are two companies in the same compound. The person who receives is the same.
Same person receiving.
Same person is received. There are only one person who is receiving the document for the both company.
I am suggesting to you, Mr. Dotto, that there are two gates, one for Jayajut, another for Gajmukh Binimay. Do you agree?
ওখানে দুটো গেট আছে, একটা জয়জুটের জন্য, একটা গজমুখের জন্য। উকিল বাবু বলছেন, আপনি কি ওনার বক্তব্যের সঙ্গে সহমত?
না,
I disagree.
all are going by same gates. Judge and others gates নেই, মানে একটার মধ্যেই সব দুজনেই যাচ্ছে।
There is only one gate, and to this gate the entrance and exit
দুটোই একটা মধ্যে যাচ্ছে।
You have said one person receives letter for both Gajmukh and Joyjut. So that person sits in the office of Jayajut or in the office of Gajmukh?
Yes.
কোন অফিসে বসেন? যে ভদ্রলোক আপনি বলেন একজনই রিসিভ করেন চিঠি, সমস্ত চিঠি বা ডকুমেন্ট গুলো, উনি কোন অফিসটাতে বসেন? গজমুখে বসেন না জয়জুটে বসেন?
জয়জুট গজমুখ একই রকম নিচ্ছে।
কোথায় বসেন উনি জিজ্ঞেস করছেন?
He is telling the only one office is there.
ভিতরে একজন নিচ্ছে।
Record, there is only one office with respect of both forms. With regard to the Jayajut as well as Gajmukh. Yes, next.
On supplementary facility. আমাদের সাপ্লিমেন্টারি এফিডেভিটটা দেবেন না? না, ওকে, আমাদের কপি তো দিতে পারি না।
Additional document?
No, supplementary affidavit there. GA1. This is in GA1.
Yeah, Lord, say something to you. I am a central government employee. I have honestly delivered 30 years. No complaint arise. So pension is running. And if I am guilty, then I will discharge.
It is not that you are guilty. Only they wanted to prove that whether to whom it was delivered. That is only, not against you with regard. It is not the case against you. Please see, it is not don't worry about it. It is not the case against you. There is no punishment against you. Only you have been called for to prove that whom the actual notice was served. That is the only question. Okay, what the question? Okay, what the question? Vakil sir, will ask.
I have delivered.
Whatever the question, he will ask you the answer. That's all, nothing else. There is no case against you. You are the witness.
He's feeling a little scared.
No.
Please show him this SA2.
Shown annexed SA2. SA2
of supplementary affidavit of GA1. GA1 of 2024. SA2. Annexed SA2. Please look at the picture
ছবিটা দেখুন
and tell me, is the gate you are referring to?
ও মাই লর্ড কেবল এটাই কি সেই গেটটা যার কথা আপনি বলছেন? ইয়েস, দিস ইজ দ্য গেট।
Kindly turn over the page. Kindly shown, witness shown annexer SA3 of supplementary affidavit in GA com number 1 of 2024. Have you seen this gate?
Yes, yes, yes.
Yes.
So there are two gates.
তার মানে দুটো গেট আছে তাই?
Two gates.
One for Gajmukh, another for Jaijut.
মানে একটা গজমুখের জন্য একটা জয়জুটের জন্য। ইয়েস।
Two gates.
Now, you said one person receives a letter for both. He sits in which gate?
আপনি বলেছেন
Gajmukh gate or Jaijut gate?
আপনি বলেছেন যে একজন লোক চিঠি রিসিভ করেন, উনি কোন গেটটাতে বসেন? গজমুখ গেটে বসেন না এই জয়জুটের গেটে? জয়জুটের। The person sit at the gate of Jayjut Industries Limited.
Both, one person receiving the letter.
One person received the letter of both the
Jayjut and
companies.
Gajmukh.
হয়েছে স্যার? গেছে।
আস্তে। না, এই বাঞ্চটাকে নেবে। এই বাঞ্চটা দেবেন। আগে যে বাঞ্চটা দিয়েছে, আচ্ছা এই বাঞ্চটা যেটা আছে তাতে
অ্যাডিশনাল জাজেস
দেখুন আমি বার করে দিচ্ছি। এই বাঞ্চটা এইখানে
জয়জুটে লেখা হবে।
হয়ে গেছে, হয়ে গেছে। The witness is shown delivery manifest of delivery manifest of Noyati sub post office. Kindly look at this document.
দেখুন।
Just beside this rubber stamp of Jayajut, there is a signature. Can you identify that person?
রাবার স্ট্যাম্পটার পাশে একজনের সই আছে, আপনি কি শনাক্ত করতে পারবেন কার সই এটা?
দীপঙ্কর সাউ।
Yes, this is the signature of Mr. Dipankar Shau.
Now, this letter you delivered through the gate of Jayajut or through the gate of Gajmukh?
Through the gate of Jayajut.
So according to you, Dipankar Shau is an employee of Jayajut.
তাহলে আপনার মতে দীপঙ্কর সাউ একজন জয়জুটের এমপ্লয়ি?
Also, he is an employee of Jayjut.
He is also an employee of Jayjut. আপনি উকিল বাবু
Yes, he stated he is also an employee of Jayjut. What you are telling?
My lord, Jayjuter.
Jayjut.
He's telling
for Jayjut.
Yes, 10 times he has told that only one person is receiving. Why you are taking the what the answer is giving? You give the answer. If you are not put to the court or to the advocate, you cannot justify all these things.
Lordship, his answer is little wrong because he says this Dipankar Shau, who received this Dipankar Shau, and he is employee of Jayjut, and he said, and also of Jayjut.
Correct.
It cannot.
Since beginning he is telling the same thing.
His employee of Jayjut also of Jayjut cannot be. That must be his some slip of tongue. That must be slip of tongue. That is why
he is also the employee of Jayjut as well as Gajmukh. Yes, next.
how you deliver letters to the office of Gajmukh or Jaijut? When you, as you enter, there is an office. There is an office.
কিভাবে লেটারটা ডেলিভার করতেন ওখানে কি একটা অফিস
As you enter, there is office on the front
front
or left or right.
in front of
In the front, there is an office.
Yes, there is an office.
In the office, what is written? Any name written in the office?
No.
No.
Where the office situates in front
Is there
or
any-
other, or by the side is answer in front. Is there any name written in the office? Yes, what is your answer?
কোনো নাম লেখা আছে কি অফিসে?
No.
There is no name in the office.
Now, just give it. You must be delivering many letters to Gajmukh.
Yes, many letters. Wherever coming.
Now, just as we said, the same person, this Dipankar Shah, he receives letter for Gajmukh as also for Jaijut.
As well as Gajmukh.
Jaijut.
Yes.
But I have shown you Gajmukh gate and Jaijut gate are different gates.
Maybe different, receiving only one letter person.
Maybe different gates, but
Receiving only one person.
but the letters and documents were received by only one person.
Mr. Dotto, I suggest to you that your statement is incorrect because the gate of Gajmukh is situated in the side road, that is Kathalpara road, and the gate of Jaijut is on the main road, that is Ghoshpara road. Do you agree?
No, I am not agree. Ghoshpara is another post office, which is Bhatpara.
It may be another post office, but the gate of Jaijut is situated on Ghoshpara road.
No, it is situated only Noyhati, under Noyhati post office, Katalpara, 77 Katalpara road.
As I told you, this Noyhati Mills is a big compound. There are two roads on the two sides.
Another side, Ghoshpara.
I have told you that Noyhati, that Nodia Mills is a big compound having two roads on two sides. The gate of Gajmukh is situated on Kathalpara and the gate of Jaijut is situated on Ghoshpara road. Do you agree?
No.
Agreed or not?
No, sir.
I am not. Yes. Let's next.
Now, when he went to deliver this letter, this Dipankar Shah, he put the stamp,
Yes.
or there is a box kept there. You, as per normal practice, you took out the stamp and put it here.
Signature and stamp both looking this delivery slip.
Who has put the stamp? You himself or the or
Yes, sir. He himself giving this stamp.
Dipankar? Okay, what is the name?
Dipankar Shah.
Dipankar Sahu have put the seal in the set. Note in the set.
Delivery manifest.
Delivery manifest.
According to you, where the gate of Jaijut is situated?
Jaijut গেটটা কোথায় আছে বলুন?
Jaijut and Gajmukh দুটো সেম কোম্পানির মধ্যে আছে, নো?
জয়জুটের গেটটা কোথায় আছে?
জয়জুটে কোথায় আছে? বাঁদিকে হচ্ছে জয়জুট, এদিকে হচ্ছে গজমুখ।
On the left hand side, the gate of Jaijut is situated.
On the same road.
Same road.
On the same road.
Yes.
Which is previously Nodia Mill.
Which was previously known as Nodia Mills.
I'm suggesting to you that for Nadia Mill compound, there are two roads on the two sides. One is Kathalpara road another is Ghoshpara Road, and the gate of Jai Jute is situated on Ghoshpara Road.
No.
আমার ঘোষপাড়া নৈহাটি আন্ডারে নেই।
No, already given the answer, Mr. Saka.
ঘোষপাড়া আমাদের
Kete
নৈহাটিতে
den,
নেই,
kete
আমাদের
den.
I think so. The Ghoshpara is not within our jurisdiction.
Okay.
ঘোষপাড়া is not under our
Ghoshpara
jurisdiction.
Road is not within our jurisdiction.
It is under the jurisdiction of Noihati.
আমাদের কাটালপাড়া রয়েছে।
Yes, next.
Along with when you took the stamp, you must have collected the AD card.
Yes, corrected.
Where did you deposit the AD card?
It will also deposit and sending to the who is sending this letter. আমরা dispatch করে দিচ্ছি ওকে, মানে মানে যে পাঠাচ্ছে তাকে dispatch করে দিচ্ছি আমরা রিসিভ করে।
We have dispatched
That's why now
the AD
AD
card
card
after receiving it. We do not have any right to hold that AD card.
To the sender. We have sent it to the sender.
We do not have any right to hold the AD card with us.
Do you, in post office, do you keep any record after dispatch of the AD card?
Everything's recording.
Everything is under record.
Everything's recording and mobile. Now is in mobile phone এখন ইয়ে হচ্ছে। It is receiving.
No, the specific whether your sub post office is keeping any record or not.
রেকর্ড রেখেছি স্যার, আমাদের রেকর্ড আছে।
We are keeping the
We are keeping the records.
Can you produce that record to court?
আপনি কি রেকর্ডটা প্রডিউস করতে পারবেন?
আমি এখন রিটায়ার হয়ে গেছি, আমাকে কিছু দেবে না।
I am retired now.
Retired person.
I do not have access to the records right now.
আমাকে কিছু দেবে।
Okay, next.
মাস্টার বলে দিয়েছে।
This stamp was made in your presence.
এই স্ট্যাম্পটা কি আপনার সামনে দেওয়া
হ্যাঁ আমার সামনে, আমি
Yes.
নিজের সামনে নিয়ে।
I'm suggesting to you that this paper was taken inside and the stamp was made elsewhere, not in your presence.
In my presence.
Not
I am
effective.
delivering this letter in my
I
presence.
disagree. The stamp was made in my presence. Stamp was affixed for the.
Can you tell my lord, since when Gajmukh, you are delivering letters to Gajmukh in that address?
কবে থেকে আপনি গজমুখের লেটার ডেলিভার করছেন বলতে পারবেন?
আমি অত আমার মনে নেই, যখন আসছে আমরা দিয়ে দিচ্ছি, স্ট্যাম্প সিল দিয়ে দিচ্ছি, কবে এসছে কি এসছে আমি কিছু বলতে পারবো না।
I do not remember the exact date, but whenever a letter
যখনই আসছে
I
স্ট্যাম্প
deliver
সিল
it
দিয়ে দিচ্ছি আমরা,
and
আর যদি না নিলে আমরা রিটার্ন পাঠিয়ে দিচ্ছি।
I deliver it to the Gajmukh and take the stamp and signature.
No, you also if nobody will be there, I used to return the
Nobody is
registered
there to receive
speed
the
post.
letter. It is returned to us and we send it back to speed.
My lord, I want to show him a plan that is coming. I mean, Lordship can keep it Monday, Tuesday, any day.
But
I want to show him a plan, a Google map, because he was telling lies.
no, if he's telling lie, how he can? You have to prove that plan by other witness, your witness, not by this witness. He has stated. Now you want to prove that his statement is not correct.
Correct.
So, and you wanted to prove that from the Google map. So Google map cannot be exhibited through him. It is the electronic document. So it has to be exhibited in process of law. To whom you wanted to exhibit, you have to take appropriate steps.
Very well, my lord.
As per.
I can show him the.
You can put the question on that. You can put the question on that. No problem. But you have to prove that through.
It is GA1 টা দেবেন।
আমাকে কিছু বলবেন আপনি মাইনরকে যা বলার
Because he is a retired person. Every day it is not good to call the persons.
এই application GA1 হ্যাঁ পেজ 35 একটু খুলে নেবেন পেজ 35
Sir.
Witness shown Annexer A at page 35 of IAGA number under bracket COM1 of 2024. এইটা দরকার না হলে দেখতে পাচ্ছি না, মানে নিতে পারছি কিনা, ডিফিকাল্ট টু গেস বিকজ আমারটা এইটা না না মিস্টার দত্ত, প্লিজ লুক at this plan.
প্ল্যানটা দেখুন।
You will find there is a if you on the oblong side along with that big area marked, there is a road called Ghoshpara Road. দেখুন এখানে দেখে দিন তো না, দেখা পড়া যাচ্ছে, it can be read.
আমাদের বিডের অবস্থান বিরাটির ওটা যে ভাটপাড়া
একটা দান কি প্রশ্ন করেনি এখনো।
আমাদের আন্ডার করছে না।
Can you see there is a road called Ghoshpara Road?
আপনি ঘোষপাড়া রোডটা এখানে দেখতে পাচ্ছেন এই প্ল্যানের মধ্যে?
দেখুন দেখিয়ে দিন অবলং এই যে এরকম ভাবে, হ্যাঁ হ্যাঁ উপরেটা রাইট।
আপনি দেখতে পাচ্ছেন প্ল্যানে ঘোষপাড়া রোডটা? মাইকে বলুন সেটা স্যার। ইয়েস,
কিন্তু ঘোষপাড়া রোড আমাদের আন্ডারে না।
but the Ghoshpara road is not under our
সেটা রেকর্ড করে।
Yes, next.
Now on the left hand side you can see another road going.
বাঁদিকে আরেকটা রাস্তা যাচ্ছে দেখতে পাচ্ছেন?
Is that Kathalpara Road?
এটাই কি কাঁঠালপাড়া রোড?
কাঁঠালপাড়া রোড
আপনার জিজ্ঞেস করছি এটাই কি কাঁঠালপাড়া রোড বাঁদিকে যে রাস্তাটা যাচ্ছে?
এটা হচ্ছে
ইয়েস।
Now can you look at the middle of this plan on Ghoshpara Road? There is an indication main gate.
এখানে একটা মেইন গেট আছে দেখতে পাচ্ছেন?
ম্যাপ বুঝবে কি করে টেকনোলজিক্যাল?
ইয়েস।
Is that the gate of Jayajut?
এইটা কি জয়জুটের গেট?
জয়জুট,
এইটা জয়জুটের গেট তাই তো? ইয়েস, দিস ইজ দ্য গেট অফ জয়জুট।
Kindly mark with the blue pencil.
জয়জুটের যে গেটটা ওটাকে নীল কালির পেন্সিল দিয়ে গোল করুন, যে গেটটা এক্ষুনি বললেন আপনি। হ্যাঁ, ওটাকে গোল করুন নীল কালির পেন্সিল দিয়ে। দ্য উইটনেস এনসার্কেলড দ্য গেট অফ জয়জুট উইথ ব্লু পেন্সিল।
মজা আসে।
স্যার স্যার স্যার
Yes, next.
So according to you, you delivered letters to Gajmukh and Joyjut through this main gate?
এই মেইন গেটটা দিয়ে আপনি জয়জুট এবং গজমুখ দুজনের চিঠি ডেলিভার করতে যেতেন তাই তো? ইয়েস।
And that is on Ghoshpara Road.
এবং এটা ঘোষপাড়া রোডে।
কাঁঠালপাড়া 77 কাঁঠালপাড়া।
দিস ইজ 77 কাঁঠালপাড়া।
Just now you said that this road is Ghoshpara Road, is written here as Ghoshpara Road.
আপনি এক্ষুনি বললেন যে এটা ঘোষপাড়া রোড এবং এটা লেখাও আছে এটা ঘোষপাড়া রোড।
বলছি তো বাঁ দিকটা ঘোষপাড়া, আমাদের এদিকটা পড়ছে কাঁঠালপাড়া।
The left hand side road is Ghoshpara road and
বরাবরই বলছি একই কথা।
our side of the road is called
কাঁঠালপাড়া। ঘোষপাড়া, আমাদেরটা হচ্ছে কাঁঠালপাড়া। ঘোষপাড়া আমাদের পড়ছে না।
Ghoshpara road is not in our jurisdiction.
So articles are already delivered. আপনি এত
Yes, yes, please. Yes.
কেন আর্গুমেন্ট করছেন না? সেন্ট্রাল গভর্নমেন্ট এমপ্লয়ি, আপনি রিটায়ার্ড পারসন, কেন আর্গুমেন্ট করছেন না? আমি রিটায়ার্ড, অলরেডি রিটায়ার্ড। All the harassment করছে স্যার।
Yes, anything further?
No, ma'am.
No further?
My lord, I only have one question. দাদা আপনি বাংলা বোঝেন না ইংরেজিতে বলবো? বাংলায় বলছি।
Defendant, plaintiff, counsel for the cross.
Okay, I will speak with him in Bengali and then I will translate into English. Do not worry. দাদা এই যে জয়জুটের স্ট্যাম্পটা আর যেটা সাইন হয়েছে দুটোই জয়জুটা করা আছে। This দুজন যে একজনই করেছে এই দুটো লিখেছে আর রিসিভ this two stamp and the signature done by the same person.
Yes, next.
So there is no কোনো অসুবিধা, the signature and the stamps
The seal
are done by
signature appearing in the, what is the sheet?
Delivery manifest.
Delivery
Manifest.
manifest is signed by the same person. Answer yes. Yes, next.
আচ্ছা দাদা আপনি ডেলিভারিটা গজমুখে করেছেন,
Sign and stamp by the same person.
গজমুখে করেছেন না জয়জুটে করেছেন?
জয়জুটে করেছি।
Have you done the delivery to the Gajmukh Private Limited or Jaijut?
The Jaijut এগুলোকে নিচে জয়জুটে।
The common, the address is matching with the cost title. The address of the Jaijut and the cost title is Kathalpara, PO Noihati, District 24 Parganas North, Kolkata 743165. ওই অ্যাড্রেসেই আপনি করেছেন? This is the registered office of Jaijut, your lordship, the address. And
Put the question, take the answer. You argue subsequently. What is your question?
you have submitted this letter on the address Joyjut, Kathalpara, Post Office Noihati, District 24 Parganas North,
Yes.
Kolkata 743165. The same address?
Yes.
এই অ্যাড্রেসে লেটারটা ডেলিভার করেছেন। Yes.
That's all.
One thing, my lord. Lordship kindly takes up the order. If he can step down.
Step down. Yes.
On 16 December 2024 order by the Honorable Division Bench.
Yes.
It was the desire of Honorable Division Bench that to examine the belief and the person claimed to have accepted the service of summons. So now he has identified that person. Those names we did not. Dipankar Shah. A summons may be issued to Dipankar Shah, madam.
Yes. But where is the address?
Same address. He said one address. Where is same address? Yes, same address. At Kathalpara, madam.
Here, therefore, since the implement is satisfied, we make it clear. The reason for setting aside the order is only enable the court to decide the service of Suppression upon the respondent after recording. Which portion you are reading?
Order is 16 December 2024,
Correct.
first page.
Page.
In view of the mode of service filed on your deposition with direct, the issue reconsider the listing is upon examine the bailiff and the person claimed to accept the service of summons upon the defendant respondent. So the person is Dipankar Shah. So Dipankar Shah may be issued a subpoena by the plaintiff.
Your lordship, the seal and signature and the stamp, everything is of Joyjut. Your lordship, if
that they will argue, but this has
it is their person, your lordship. He will say that he has
receipt है ना? Delivery memo.
Delivery memo दिखाइए my lord को.
अरे अभी जिसने
Additional
आंसर दिया हो पोस्टल अथॉरिटी का.
अरे ये तो भूल गई.
A document, manifest. ছবি না দেখালে বুঝতে পারছেন না।
additional
Not,
judges
not
brief
yet. There is another
there is
file.
additional judges brief আমরা দিয়েছি ওটাতে লাগানো আছে সবকিছু
Maybe
Can I-
not file it, maybe
can I assist your lordship
Where it is?
এই তো
Where is the original? अरे postal का था नहीं original. हाँ वही that is. Yes. Yes, Jajut.
It's Deepankar Shao.
Record and all.
your lordship this can be kept as a part heard your matter your lordship because in your lordship kindly your lordship
Evidence stage. How the part heard?
Your lordship again we have to start we have to start your lordship kindly consider your lordship it's a humble request your lordship I humble request your lordship we want to do it before your lordship only your lordship kindly
I having so many.
as part heard your lordship in
The
Well, I join issue with my learned friend.
witness, namely, what is the good name? Is present and has filed affidavit showing the reason why he has avoided to accept the summons, accept the subpoena issued by this court for his appearance as witness. Counsel for Mr. Manoj Kanti Datta submit that in the affidavit at paragraph 5, subparagraph C, in the first line, the month is to be read as August 31st, 2005, and the date is to be read as the date to be read as August 31st, 2025 instead of July 31st, 2025. And in the same paragraph, in the subpara, wherein the memo is enclosed, the date is to be read as August 5, 2025 instead of February 5, 2025. In view of the above, in the affidavit filed by Manoj Kanti Datta at page 5, paragraph 5, subclause 6, the date shall be read as August 31st, 2025, and in the subpara, the date shall be read as August 5, 2025. Full stop. The Manoj Kanti Datta was examined and cross-examined and discharged. Full stop. Counsel for the defendant submit that the witness has specifically made an statement before this court. The postal cover is received by one
Deepankar Shao, he said.
One Deepankar Shahu.
Shao. S-H-A-W.
S-H-A-U.
W.
S-H-A-W. Shahu. Who of the Jajut and Industries Limited. Accordingly, the defendant intend to examine the said witness in terms of the order passed by the Honorable Division Bench, Honorable Appellate Court, dated 16 December 2024. In view of the above,
December.
The defendant is directed to take appropriate steps for furnishing such requisites in the department for.
We will deposit. They should deposit, my lord. Plenty should.
You are calling.
I will examine him, but it is
we do not have the address my lord
they have to get the address. Same 77 Ghatalpara Road.
just to bole
For issuance of subpoena upon Mr. Deepankar Shahu, who is alleged to have received the postal cover from the postal authorities having addressed Jay Jute and Industries Limited within bracket formerly Nadia Mills Company Limited bracket goes Kanthal Para, PO plus PS Nahati District 24 Pargana within bracket North West Bengal 743. What is the number? 743
State level.
152. 152. Let the matter appear on date the examination. What time? Huh?
Date, my lord?
2nd December at 3 p.m.
Your Lordship,
Huh?
Your Lordship, one leave may kindly be granted for WS filing.
Confirmed.
Your Lordship,
When you
can it be kept in the month of November, Your Lordship?
number कोई date है क्या? I have no date. It is a witness action all the time. If you want the specific time, then it will go to December.
They can
We are extremely sorry for holding that.
court, my lord, and
yes.
spoiling the lunch.
Yes.
And my apologies, my lord.
It's
Our
okay. So,
apologies.
no, because I have said because he's a retired.
Yes,
person.
lordship.
It's already been affirmed.
When you receive the
Lordship is
written
very
summons,
kind.
The written summon in the sense, Your Lordship, that is
120 days is over.
it is getting over by
वो
tomorrow.
दे दो. Leave is granted to the defendant to file return and to submit the return statement in the department in course of the day, subject to acceptance.
Your Lordship, much grateful.
Deeply obliged.
mention a matter, my lord, item number 9 and 10, fixed at 345, my lord, this is a contempt matter. There was a direction upon Superintendent of Police to appear virtually. My lord, there is a full court resolution. My lord, I was only hoping that there's a full court reference. So in that event, my lord, in the event,
Where is the full court reference?
I mean, not 330, there is a 330 resolution, I'm sorry. Yes. So in that event, whether this matter will be taken up or not, in that case, I have to arrange for a link.
Which was the petitioner?
No, no, I am for the
Item number
9 and 10.
9
That
and 10. 9 and 10. 345. Yes, the matter will not be taken because 345 will.
So in that event, I am informing the Superintendent of Police that there is a resolution. Much obliged, my lord.
Yeah, it will also sign up the matter on the regular original side, your lordship. But item number 58 of today's daily list, your lordship, just the special citation needs to be issued. Your lordship had already issued it. Just a modification of your lordship's order because we issued it in a German newspaper.
Call the list. Huh? It should be mentioned, है ना first.
Item number 1. I appear for the contempt, my lord. The contemptor's son has suffered a brain stroke. The father of the plaintiff and the son of the contemptor number 1. My lord, he is in hospital currently. My lord, I could not obtain the instructions. But the order has already been complied on 1st August. Only thing, after taking inspection, they have said that the building plan that I have given is revised building plan and they need the mother plan now. Now, my lord, let the mother come back from the hospital. My lord, kindly keep it after vacation.
But
in the opening week.
As per the prayer made by the counsel for the alleged contempt, let the matter appear.
Opening week, my lord, I shall take instructions and
Let
file
the
it.
matter appear on 7th of November 2025 under the same heading.
Deeply
Yes.
obliged.
There are 3 contemptors. There are 3 contemptors.
Only direction.
Is a contemptors. No, all. On the contemptors, the 3 contemptors.
The order, original order, direction was upon the mother only.
Yes.
Deeply obliged.
But she will record that will kindly that because of the ill health, because there was no medical certificate produced.
I'll bring it if my learned senior friend requests, my lord.
Call the matter.
Number 3.
May it please your lordship.
The advocate will continue. Will you call the matters? They will continue up till 9 o'clock. Yes.
May it please your lordship. Well,
Yes, have you prepared that chart?
my lord, we have
Not.
we have prepared, my lord, the chart, and my lord, I'm told, my lord, so far the report of the police that is filed before your lordship, my lord, may your lordship kindly have a look to that. For the time being, my lord, those are the tenants. If your lordship may kindly, my lord, consider that part, you should report it out.
Yes.
Because what I had understood, my lord, that was fallen from your lordship. The lordship is only concerned for the time being just to collect, my lord, the rents for the month wise. Then your lordship would pass appropriate order for the administration.
Correct.
Because they cannot also use and waste my property because I am also a
Correct.
legatee.
Correct.
Now, lordship may for the time being go by the police report. Police report says about that for the time being who are the occupants, both as statutory and non-statutory, I mean the private parties, my lord. So, my lord, I may be permitted, my lord, to collect the rent and to deposit in an escrow account, which may be subject to, my lord, lordship's further order, my lord, as may be suitable, my lord.
And you have taken any steps regarding after the death of this?
Yes, my lord, I'm
you
told, my lord,
taken?
yes, my lord, we have already, my lord, my lord, the application has already been affirmed. The master summon is to be taken up in course of the day. If lordship commences, my lord, kindly keep it any day in the next week. So that by that time, my lord, I believe my AOR, my lord, could, the application affirmed, application has been affirmed, my lord. This is the original copy that would be ultimately, my lord, would come before your lordship, my lord, as my lord's brief.
Yes.
I'm grateful, Lordship. একটু জজের কাছ থেকে নিয়ে নিন।
So as per the police report, in the ground floor, there are 5 tenants. There are 5 tenants.
As per the police report.
As per the police report. And the first floor, there are 3 tenants. Second floor, there are 3 tenants. And third floor, there are 1 tenant. There is 1 tenant.
Now, my lord, this may be considered as without prejudice because I have not yet, my lord, so far administrating the property. Because this only I have to also go by the police report. There might be some other persons also.
Since when they are not collecting, when she died?
She died, my lord, August 14th.
August 14th.
14th. So, my lord, let there be also, my lord, it may be ascertained that whether August rent was fully paid or not.
Yeah,
along with
I
that
mean,
September.
BSNL authority, you are for the BSNL.
Police report.
When the last payment was made by the BSNL authority? July. So August onwards it has to be paid.
No, my lord, paid in July, but for which month? That kindly lordship ascertain.
August. Yes, which
No,
one?
maybe for the June he has paid it in July. Because I do not know what are the system. Usually, my lord, rents are being paid in advance.
What
Okay,
record says? BSNL का report
BSNL
देखो।
পুলিশের রিপোর্টটা দাও। এটা তো কিছু নেই।
July 2025. July 2025. June 20. Yeah, July. Now August he has to pay.
August. So they say, my lord, up to July, for the month of July, it's paid. Very
So
well.
I am passing an order from the month of July. If it is due, then the court will
My lord,
take.
then also, my lord, give a liberty, my lord, in order to ascertain, my lord, whether the such money has been paid from the not, that is from the tenant. Tenants are liable to produce.
Who will collect this?
My lord, for the time being, applicant may be given, given direction. I understand, my lord, I understand, because only the thing is, lordship, my lord, or in the event, my lord, my aware.
Who
Advocate.
is the advocate on record?
My lord, Mr. K.M. Hussain.
Where is his site?
My lord, everybody decides that Kolkata and property is at Midnapur.
Kalyani.
And my lord, the property, no, not Kalyani, my lord, Midnapur.
Midnapur.
West Midnapur. Yes, that is why your lordship is.
That's why I'm passing an order for the interim. The special officer will collect the rent and he will open the his account and the amount will be deposited and he will submit
Directly paid
to the special officer upon.
My lord, I am told, my lord, Mr. Hussain stays very nearby. Mr. So if lordship, my lord, permit. He is a very nearby, my lord. He is very next to neighbor, my lord. Very next to neighbor. Not very, but within the same panchayat or like this area, my lord.
Same thana.
Same thana.
Learned counsel for the petitioner submit that the application is ready. The application is ready, but it could not be affirmed with regard to the deletion of the name of the executrix from the cause title of the instant proceeding and for substitution of the legal layers of the executrix. He submitted he will file appropriate application within a week from date. Full stop. He further submit that due to the death of the executrix, nobody is collecting the rent from the persons who are from the tenants and the persons who are in occupation of the premises in question. He further submit that there is no other persons and there is no persons to pay the municipal taxes, electrical charges, electrical consumption charges and other taxes with regard to the said property after the death of the executrix. Accordingly, he pressed for appointment and special officer. Press for appointment of the petitioner. He is the petitioner, Cavitrix. Petitioner slash Cavitrix, namely
Shongita Maiti. He is the youngest daughter.
Shongita Maiti, who is the youngest daughter of the testatrix.
And having my lordship may record the equal legatee right.
Be appointed as an administrator for the time being to collect the rents and payment of the taxes with respect of to the concerned authorities with respect of the property in question. Full stop. Had the learned full stop. Had the learned counsel for the petitioner / applicant. This court at this stage it is not intending to allow the applicant, namely Sangeeta Maiti, to act as an administrator. And as such, for the time being, this court is of the view the advocate on record of the applicant, namely you, no, you,
K.M. Hussain.
Jayed Hussain.
You are not the advocate on record.
No, in that I am.
Who is the advocate on record?
Mr. K.M. Hussain.
He will do that.
But he stays in Kolkata. He
What is
stays
hiding?
there.
What is the good name?
Sheikh Jayed Hussain. इसके जायद
हाँ, क्या बोला? Non-advocate on record. The advocate, Mr. So advocate, who is appearing on behalf of the applicant of the petitioner in the matter, is appointed an special officer for collection of the monthly rents of the tenants and the occupiers of the premises in question from the month of August 2025, and also to pay the required and the municipal taxes, electrical consumption charges, and any other taxes, if any, to the concerned authorities, and to maintain the proper account. The special officer is directed to open an separate account and to deposit the rent collected by him from the tenants and occupier of the premises in question until further order, and to submit the report before this court as and when required by this court. Full stop. The special officer is provided with the report submitted by the inspector of police, inspector in charge, Nandigram police station, Purba Medinipur, wherein the details of the tenants and occupiers is appearing
for the present.
And the special officer is directed to collect the monthly rent in terms of the said report and to deposit the same in the bank and to pay the taxes, if any, raised by the concerned authorities. Full stop. This order may be communicated to the special officer, as well as which bank you will open here only. It is better to open in High Court. Yeah.
To Lordship's direction anywhere.
Huh?
As your Lordship's pleasures.
So it is better to you to maintain the account here. Otherwise, you have to. No. The special officer is directed to open the account in the State Bank of India. State Bank of India.
State Bank of India.
State Bank of India. High Court branch. High Court
main
branch.
branch.
Not
High Court branch.
Main branch. High Court, not High Court.
PNB High Court branch.
Main branch. Kolkata main branch. Kolkata main branch. In his name as a special officer of this court of this case, for the purpose of depositing the monthly rent and for paying the taxes to the concerned authorities with respect of the premises in question.
Milord, one point, Milord. Lordship has permitted the special officer to collect the rent from July onwards, August onwards, and for the time being until further order. So, Milord, that may include, Milord,
continue to collect
the
monthly rent from the August 2025 until further order.
And Milord,
all the tenants and the occupiers of the premises.
Milord, kindly record month-wise, otherwise tenants may create a problem.
All the tenants and the occupiers of the premises in questions are directed to pay the monthly rent month by month
to the
special officer without any restraint, without any objection. Without any objection, and the special officer shall provide the rent receipts to the occupier of the tenants of the premises in
My lord, one more thing, lordship, from the reports already filed before my lords by different authorities, it would luminous, my lord, there are certain substantial outstandings not being paid. My lord, if your lordship,
That's why let the legal years come, then we'll see to that. Now what you will do?
no, what I can say, my lord, the special officer may be permitted to realize those unpaid rents, which are already on the record, admitted by the authorities.
At present, I am not.
Very well. Very well.
Bank details. Kindly direct the special officer to communicate the bank
It
details
is made
to the
clear that
so that they can
if
pay the
any of the occupier or the authority or tenants intend to pay the monthly rent by depositing in the bank, comma, the special officer shall provide the bank details to the occupier or the tenants for the purpose of depositing the monthly rent, and the occupier slash tenant shall provide the documents to the special officer to prove that they paid the
I'm
monthly rent, deposited the monthly rent from month to month of the premises in question to the special
My
officer.
lord, one more thing, my lord, this IC Nondigram PS may be directed to assist the special officer. That
It
may be
is,
recorded. my
yeah.
lord.
It is if the special officer is facing any difficulties for collecting the rent or collecting rent from the tenants or
Including
the
on
occupier
maintenance and administrative.
by entering into the set
I'm grateful.
premises,
I'm grateful.
comma, the special officer is liberty to make appropriate complaint to the to make appropriate request to the concern to the officer in charge Nandigram Police Station, Purva Medinipur, and if any request is made by the special officer, comma, the officer in charge or the competent police officer shall provide the police protection to the special officer for collecting of the rent and to maintain the property in question.
I'm grateful.
Question.
Lordship, kindly give,
further
give a my lord, give a returnable date, my lord, so that I
Yeah,
can
let
come up
the-
with a substitution
yes.
application.
Not necessary. Not necessary. Let the matter appear on 22nd November, 21st of November 2020. Though the London advocate appearing for the BSNL is appearing for last several dates, but this court finds that at this stage the appearance of the London advocate on behalf of the BSNL authority is not required.
Lordship has made it returnable on 21st of
1st of
November.
November.
But it may be at 2 p.m. my lord, so that the substitution application may be
Yeah,
hard.
if this court will having the determination, then
No, Lordship is a part-heard matter.
Part-heard matter. Then we'll see to that. What?
But kindly mark it at 2 p.m. Otherwise, my lord,
No,
there are
2 p.m.
certain.
I cannot. At this stage, let it become. If
Very well.
this court continue,
Very
then it will be at 2 p.m.
Very well. Very well. I'm extremely grateful, my lord.
Yes, next. क्या ढाई बजेगा नहीं नहीं है कोई record an order. The matter was listed on 12th of September 2025, but on the date fixed, none appears on behalf of either of the parties. Accordingly, either of the parties and no accommodation was sought for, and accordingly the matter was placed in the warning list. As per the order dated 12 September 2025, the matter was listed in the warning list, but in spite of the same, none appears when the matter is called today. Considering the above circumstances, this court finds that the plaintiff is not interested to proceed with the matter. In view of the above, CS 137 of 1992 is dismissed for default. Interim order, if any, stand vacated. कोई interlocutory नहीं है ना? Interlocutory application, if any, also stand disposed. बस सब में यही ऑर्डर कॉल करो, देखिए नहीं यही ऑर्डर कर देना. ओए, तू ना करो बात को. Yes, call the matter. Same order.
Item number 15, item number 16, item number 17, item number 18, item number 19, item number 20, item number 21, 22, 23,
24, 25, 26, 27, 28, 29, 30, 31, 32,
31. Up till,
32, I am for the response.
up till 13 to 31. Oh, Dada. 13 to 31. All same order. अलग अलग ऑर्डर होगा, सेपरेट ऑर्डर होगा.
to 30, item number I
5, 8, and 5. Sorry, 5, 6, and 7.
না 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 গোপাল এলে ওইদিকে করে আবার আপনি আপনি
Yes, 5, 6, 7. What is the matter?
But I'm told your lordship had already gone through the division bench as well. But kindly come to the order of the division bench. But kindly come to paragraph 42. Your lordship has a copy, or should I give it? But kindly come to 42.
42?
Yes.
Yes.
In the present case, admittedly, Rule 1 of Chapter 13 has been resorted to, and as such, the scope of consideration, original side rules is confined to orders in the nature of declaratory decree on the said question. So there, since there was no interlocutory application, the Honorable Division Bench has held that the reliefs, the questions framed are only under Rule 1. Then, my lord, it is well settled that interim relief of a nature greater than the final relief or beyond the scope of the final relief cannot be granted in any suit proceedings or adjudicatory process. Hence, in the instant case, by issuance of an ad interim order of injunction, the learned single judge has traversed beyond his jurisdiction and touched the corporeal rights in respect of tangible and immovable properties, stricto sensu falling outside the ambit of determination of questions and matters within the contemplation of Rule 1 of Chapter 13 of the original side rules. The scope of Rule 1, it is reiterated, is confined to the determination of questions or matters stipulated in Clause A to G without an administration of the estate of the trust. Hence, such power is limited to the determination of question and not to grant of relief touching the estate of the trust.
Yes.
Then, my lord, State Bank of India is considered. I am not troubling your lordship. Then straight away, my lord, come to my lord. Kindly come to paragraph, my lord. 51, my lord. 52, my lord. It may also be noted that no relief in the nature of injunction, for that matter, any relief touching the estate of the trust or any property, movable or immovable, has been sought by way of relief in the originating summons or the supporting affidavit in the present case. Also, no interim application was filed in connection with the proceedings before the learned single judge, nor was any final or ad interim relief in the nature as granted by the impugned order sought by the plaintiff respondent at all. In fine, we are of the considered opinion that the learned single judge heard in law, basically, my lord, on the if I have in my reading, my lord, now, my lord, kindly before I summarize, kindly takes the original side rules once, my lord. Rule 1 and Rule 2. Kindly see Chapter 13, my lord, Rule 1.
Yes.
Kindly see the Rule 1. The executor or administrators of a deceased person or any one of them and the trustees under any instrument or any of them and any persons claiming to be interested in the relief sought as creditor, legatee, heir or legal representative or as beneficiary under the trust of an instrument. This is where we come in, beneficiary under the trust of an instrument. Or, my lord, kindly omit the rest. Kindly straight away come to, my lord, may take out as of course an originating summons returnable before the judge sitting in chambers for such relief of the nature or kind following as may by the summons be specified and the circumstances of the case may require, that is to say, the determination without an administration of the estate or trust of any of the following questions or matters. Now, my lord, kindly see E. Directing the executor, administrator, or trustees to file any accounts, vouch the same, or to do or abstain from doing any particular act in the character as such executor, administrator, or trustees, and my lord, G, my lord, determination of any question arising in the administration of the estate or trust, and my lord, this is really my lord the scope. E and my lord G are the scope which we are concerned with in the present originating summons. Now, my lord, kindly now see rule 2.
Yes.
Rule 2 says, order for administration of the estate or by the trust. Any person named in the last preceding rule, that is rule 1, in the like manner, apply for and obtain an order. This speaks of order for administration of the estate of the deceased, administration of the trust, and see discharge of the executor, administrator, surety, and refund of security deposit, if any. So, my lord, in my respectful submission, the Honorable Division Bench, in that particular case, in that appeal, has held that since there was no separate interlocutory application, no case under Rule 2 was made out to obtain an order for, my lord, in that case, administration of the trust.
But kindly read the 53 ones.
Yes, my lord. Right on, correct. Yes, my lord. In fine, we are of the considered opinion that the learned single judge erred in law in exercising jurisdiction not vested by passing an order of injunction. Yes, that is because
Continue.
touching the administration of the estate of trust as well as the corporeal rights in the property movable and immovable, which is beyond the scope of original summons under chapter 13 of the original side rule, particularly in the context of rule 1. That is what I am saying.
Issue notice, I am not satisfied. Issue notice.
But I have already issued notice. I've served upon him, my lord, both the originating summons and, my lord, the interlocutory application.
My lord kindly gives us 3 weeks time after the vacation to file.
No. You are one, I am fixing on 1 week I am giving after puja vacation, 1 week there, then I am fixing on 21st.
Man.
And in that event also kindly keeps the question of maintainability open.
Yes, my lord, maintainability kept open, my lord. Kindly, my lord.
At this stage, this court is not intending.
My lord, may I do something? My lord, so kindly don't take me amiss. Since your lordship has been very kind enough to indicate your lordship's mind, my lord. No, absolutely. My lord, may I then, my lord, not press the interlocutory applications? Let them just, my lord, take, my lord, the file, my lord, the answer to, my lord, the main originating summons suit. Yes, I'm not pressing.
Then at counsel for the plaintiff has not pressed
because more or less I know
the interlocutory application being GA.
My lord, GA will
One
in all the matters.
GA1 of 2025. Accordingly, GA1 of 2025 is dismissed, has not pressed. Dismissed and not pressed. Full stop. Notice received with regard to the
originating summons, yes.
My lord, we have received it, but subject to the maintainability, my lord, keeps it open, my lord.
This is also received by the defendants with regard to the originating summons suit. Accordingly, the defendants are directed to file a written statement by.
Kindly give us
file written statement. File written statement. This is the matter. Written statement. So maintainability, you can take the maintainability point.
We'll do that.
Nothing
Yes, my lord. Well, that is okay, fine. Yes, my lord.
The matter appear on. When you received.
Sir, I mean, actually, forwarding letter. My lord, we received on the 11th of September.
11th September. So 11 November. 21st of November. 22. The order passed by the Honorable Division Bench in APOT number 223 of 2025 be kept with the record.
Well, similar orders then in item number 48 also.
48 minutes from which minute we went up to appeal.
The
only difference is, there is no GA.
There is no GA. Just the extension of time.
48.
48.
48.
48. So not press, question of not press does not arise, only my lord.
It is already over.
Yes, they will only my lord file.
Consult the defendants press for time to file a written statement. Let the written statement be filed within. When the time to file written statement is extended, let the matter appear on 21st November.
Same.
Wait for a minute.
इसमें खाली फर्स्ट वाला एक में रख एक फर्स्ट में करो यस item number 32.
I am appearing on behalf of the defendant.
Yes. Who is for the plaintiff?
Plaintiff.
Lord, I am appearing on behalf of the defendant.
Yes.
The plaintiff's application, Lord, for judgment upon admission. But I intend to, Lord, make the arguments in front of the plaintiff at least. Because I am too, Lord.
No,
for
they
your
already
lordship.
argued.
I have argued.
You're
In
on.
fact, this is
You're
going
in
on for quite
reply.
some time. No, Lord, I am the one who is objecting to the grant of the judgment upon admission. So I had already shown your lordship, Lord, the factual matrix. I had, Lord, distinguished the judgments.
Who is appearing?
Miss
Ujjani Chatterjee.
Yes. Maybe, Lord, everyone was looking at your lordship's heavy list today. We were all expecting that one after the other, there are blockbusters. Then keep this matter, Lord, first week of October.
On behalf of,
I'll inform Ms. Chatterjee, Lord.
So and so appearing for the defendant and appears on behalf of the plaintiff. Let the matter appear on 14th November.
I'll inform.
14th November.
No, 33 is my application, my lord. Although your lordship, my lord, had passed an order in this matter, this is Dhandaulat matter, where, my lord, the fire department and the Kolkata Municipal Corporation, my lord, were directed to
why this
furnish a
why
report.
this matter is here?
Yes, because this is an application, my lord, where I have, my lord, sought for a modification of your lordship's order. If your lordship, my lord, kindly sees my prayer,
Who is
the
for the
only
other
thing
side?
that they were all throughout represented, my lord. Lordship can. It's very short, my lord, ambit is, I only want the copy of the report to be given to me.
But report has to come.
That is exactly, we didn't know, my lord. So if your lordship, my lord, can kindly indicate in your lordship's order, at least today, that the report should be filed by the...
By which order? Order dated?
Lord, I'm handicapped, my brief is not here, but it is there, my lord, as a part of the...
My office is very intelligent. They are not keeping the order in the file.
But it seems that, my lord, the lordship has exceeded everybody's expectations. Milord can pass over this matter, Milord. I can assist your lordship. My GA, it is annexed with my GA, Milord.
Nobody is able to catch me with that speed.
That Catch Me If You Can. That's Tom Hanks. Very nice movie. Well, it's annexed with my general application, Milord. It is that order where your lordship, Milord, was pleased to pass.
Yes,
by disposing several applications and. Hey, November.
Which application number?
Milord, the application which is appearing before your lordship, Milord. GA. No.
GA2.
आज के धंधौलत था तो देखो
कौन सा फाइल है?
GA2.
No, it is another matter. Gunman Trader. That is
no, item number 33 has been called.
Gunman Traders.
No, I'm sorry, Milord. I'm not.
Gunman Traders. Yes, you are not. None appears on behalf of either of the parties. Let the matter appear on 21st November. Yes, next.
My lord, I am opposing this application. My lord, your lordship was pleased to heard the my lord petitioner, who is the defendant here, and I request your lordship kindly see the notes which your lordship has made in your lordship's brief.
My lord, it is an application under Order 7, Rule 11 for rejection of plaint on two grounds, my lord. One is for limitation and other is, my lord, I should file this suit in the commercial division.
Yes.
My lord, if your lordship kindly grant me leave to proceed with the application in the process of giving reply to
The other
that.
side.
But this is a matter, my lord. Always it pricks everybody, but they are not appearing. Your lordship was pleased to heard them, my lord, extensively, my lord.
Correct. I have taken note of it. Yes. Not today.
My lord, then first week of November, my lord.
Welcome. Okay. As none appears on behalf of the defendant, for the interest of justice, case is adjourned. Let the matter appear on 7th November.
At 2 p.m., my lord.
Naturally.
At 2.
Yes. एक पार्टेड नहीं है, ये वो नहीं है, फिक्स मैटर नहीं है। 345 300 में ठीक है। ये सही है धंधोड़। None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of December 2025. Next.
Your Lordship, I am for the defendant in this matter.
Yes.
This is that club matter, Your Lordship. We have preferred an application for conducting the SGM, but we have also, Your Lordship has directed us for assignment of the GA4 in your list, but we have done the same. We have written a letter to the OSD on 19th August, but the same is not reflecting till yet of.
Which matter?
This is that club matter, Your Lordship.
Item number?
Item number 36. We have preferred an application for conducting SGM. That application was on board few days back in Your Lordship's list, but back then, during the extension of interim order, Your Lordship has directed us to.
Yes, I cannot because I have no jurisdiction. I have determination.
Your Lordship, we have written a letter to the OSD. Your Lordship has directed us to file that to direct Your Lordship that for assignment. We have written that, but today is not.
No assignment. So what can be done? So what about this application GA4?
Yes,
the same.
Because the department has told us that it will be there on board. That's why I am just.
Board is there, but without the assignment, how it can? ये पाठक क्यों लिखा है इसमें?
In respect of GA1, Your Lordship, we have the order was of February 5. It was parted.
Yes. What about the GA4?
GA4 is already in board. Your Lordship,
what is the GA1?
I'm late by Mr.
I apologize for not being on time.
This is for Milord, the assignment which Milord had fallen Milord from your Lordship.
GA4 I cannot take.
GA1 indicate very briefly what the point was. Time recapitulate, Milord.
Maybe, but the GA4 I can't take without the assignment. But no assignment.
I'm at a loss here, Milord. I do not know what. Because, Milord, I'll tell you, Lordship, what is the issue here. Milord, the main injunction.
Without assignment, how?
I understand. No, Milord, I'm not making any submissions on GA4. I'm only indicating, Milord, GA4, why it is important, Milord, why it is necessary to be listed before your Lordship. The difficulty, Milord, the injunction petition is before your Lordship. Milord,
GA1 is my
that's the injunction petition, not by my learned friends. The petition which, Milord, we are seeking assignment, Milord, before your Lordship is, Milord, with an alternate prayer that in the interregnum, Milord, without the injunction being, Milord, contested,
the relief which is, my lord, agreeable to both the parties could be, my lord, then granted by your lordship. Hmm?
Yes. No, it is assigned.
Then kindly, my lord,
Yes.
any day that
You will
suits your
get-
lordship will come back, my lord, because this is something which will.
Which for the other side?
I am for the
Balance
petition
is
number.
appearing.
Here for your file affidavit.
No, no, no. GA4, no
You will
affidavit.
not file.
It was not
Will
hard.
not file.
Man, we will file the affidavits. And in GA1, the interim order is expiring today, man.
This is the same interim order, my lord, which we oppose to every time, my lord.
Every time the 100 print opposes, man. If my lord extends the interim order and fix a date after the vacation, my lord.
Counsel for the, you are for the defendant.
I am for the plaintiff.
Counsel for the plaintiff is for time to file affidavit in opposition in connection with
Mr. Thakkar is leading me in this matter. my
GA4
lord.
of 2025. That affidavit in opposition is filed by, how much time will take? 1 week after vacation?
After vacation, my lord.
1 week after vacation?
1 week after vacation.
1 week after vacation. Reply if any there to be filed within a week thereafter. Let GA1 and GA4 be placed for hearing on. ये नवंबर में कोई टाइम है?
hearing করছো না কেন?
Then it will go to December if I want to fix the date and time.
My lord, any day that suits your lordship, time, my lord, whatever suits
That's
your
why
lordship.
that's why I ask. कब है first time कब है?
এটা কি ও রিলিজ করেছে? এইটা আমার নয়, এইটা থেকে সব এইটা দাও না, আমার হাতে লেখা আছে। বলে
12:30 कब है बोला?
কিছুই হলো না, হয়তো ছুটে এলাম।
Second December.
2nd December, very, very deeply obliged.
2nd December 2025 at 12:30.
Deeply obliged.
Interim order is extended till 2nd December 2025 or until further.
Deeply obliged.
Article 37,
before you got the point of 37.
Extreme indulgence. Will not reprimand.
Yes.
Item number 33. My learned other side is also here. The Lordship has extended it, kept it returnable on 21st November. No issue. Interim order is expiring on 23rd. 23rd. Tuesday. Till 21st.
No. So instance appearing for the plaintiff. You are appearing for the defendant.
number 1, 2, and 3.
Instance appearing for the defendant. The counsel for the plaintiff place for extension of interim order. Interim order is extended till 21st November. Let the matter appear on 20th.
So. I was so morose in withdrawing the application. I was outside. I forgot I have a matter.
Also. 37.
None appears on behalf of either of the parties. No accommodation is sought for. It is fine from the record. The plaintiff has filed the present application being GA3 of 2025, praying for recalling of the order dated 6th of July 2022. Wherein this court has dismissed the suit being CS number 119 of 2018 for default. When the matter is called today, none appears on behalf of the plaintiff, no accommodation is sought for. This court finds that the plaintiff is not interested to move the instant application. Accordingly, GA3 of 2025 dismissed for default. Yes, next.
May it please your lordship, my lord. This is my application for modification of your lordship's order,
Lord, I'm appearing for
where I
respondent.
have not sought for any relief against any of against the defendant. My lord, by your lordship's order of 19th June 2025, which your lordship will find at page 193 of volume 2. Your lordship's specific observation with respect to GA6.
No challenge. No challenge.
There is no challenge to this order. This order and the Millard, your lordship has seen, Millard, the time to file the appeal has already expired.
Yes.
So this is binding on the parties. Millard will kindly see your lordship's observations. Your lordship so please to frame certain queries onto the fire department and the Kolkata Municipal Corporation.
Yes.
Millard, I am unaware whether they have at all filed any report or not, because we have not been served with any copy of the report. It's not about them, it is about the authority.
We have not even received any copy of any report, my lord.
Yeah, sure.
My lord.
Yes.
So, Millard, if your lordship, Millard, can kindly direct the department to comply with your lordship's solemn order, Millard. And this matter can be kept, Millard, after
the notice was served upon, issued upon them.
Yes, yes.
When you issued the notice.
Notice they were just a My lord will have a look
on
at Millard,
page number
page
209.
209.
209.
Yes, volume 2. The notice is dated June 23, 2025. Your lordship's order was 19th June 2025. We served the notice on 23rd June 2025. The queries which had fallen from your lordship is at page 202, because these needs to be answered by the authorities.
203.
202, 203.
203. No? These are the questions.
Yes. Paragraph number 23. Milord.
By an.
Yes.
Yeah, order a judgment by a judgment dated 19th June 2025. This court directed this court has passed the following order. Following order, paragraph 22. Yes. Yeah. The order dated 19 June 2025 was duly communicated by the plaintiff.
Yes,
by the plaintiff to the concerned authorities, that is director and to the concerned authorities by a letter dated 23rd June 2025, which was duly received by the concerned authorities on 24th of June 2020. This court also found that no report has been submitted before this court, as no report touched on record of this court. In view of the above, the authorities, namely the director,
203.
PIO, the director SPIO, West Bengal Fire and Emergency Services, Government of West Bengal, Office of the Directorate, ये तीनों का है ना, 1 2 3 4 5 6 5 का इनको 1 2 3 4 5 क्या बोला are directed to comply with the order passed by this court dated 19th June 2025 and to submit the report before this court on 14th of November 2025. It is made clear that by the date fixed, if no report is submitted by the authorities concerned, appropriate order will be passed. The plaintiff is directed to communicate this order along with the order dated 19th June 2025 to the concerned authority, to the said authorities for compliance. Let the matter appear on 14th of November 2025 by filing report by the authorities mentioned above.
One humble request: we will definitely serve. Lordship would also direct the registry to serve. Let it also be served from the court.
It is fine that in spite of the receipt of the notice from the in spite of receipt the copy of the order dated 19 June 2025 from the petitioner, from the plaintiff, the authorities have not complied with the order. Accordingly, registrar original site is directed to forward the copy of the order dated 19 June 2025 along with this order to the authorities, to the concerned authorities for compliance and to submit the report before this court. इसको ऊपर हो जाएगा.
I'm deeply obliged, Milord.
Then disposed of this one.
No, Milord, that is my prayer is so that they serve it to me. Your Lordship has asked them to serve it.
It will come automatically. It will serve.
No, Milord, kindly let the application remain. That is, the files remain. In that case, the files remain before your Lordship. Deep love.
नहीं, उसके बाद फिर वो आएगा फिर फिक्स.
There is a 3:30 today, but my matter is that in contempt matter is fixed at 3:45. So you possibly not be possible because I'll take around an hour's time to complete. But then Milord, can it be fixed after the
Item number?
Well, item number.
Item number कौन सा 8?
Yes, Milord, I believe so. Just give me a moment.
I appear for the alleged contempt and
Well, 11. Item number 11. 3:45.
Sane, that's
Item number
11.
11, and that will not be taken to.
That's what I'm saying. So, Milord, interim order be extended. Only that, nothing else.
I was only receiving. I know, Milord, it's an unreasonable prayer, but still I'm making. There's some difficulty which my client is facing. There is an interim order in this contempt application. There is also a suit before the Kalipok. Because of the interim order here, my certain rights of my client are being prejudiced. That is my instruction.
Till now, he was fine.
Whatever I'm submitting is on instruction. So, if this matter, I am making a prayer. If it's
First day
possible,
of reopening? Kindly fix it first day of reopening.
That was my
28 October at 10:30.
Yes.
Yeah, right.
28
Goes us to make submission.
28th October, 10:30. And Milord kindly extends the interim order. That's all. This is the
Item number 11.
11. Milord.
Item number 11. Though the matter is picked today as 3:45 p.m., but due to the bar resolution, the matter could not be taken up for hearing. Accordingly, counsel for the plaintiff prays for extension of time, extension of interim order. In view of the above, interim order is extended till 7th November 2025 or until further order. Let the matter appear on 7th November.
The matter may be
7th November.
7 November. Will Lordship be kind enough to record my formal objection?
Vehemently opposes.
Prayed for extension. The counsel for the defendant raised objection for extension of interim order, but this court find that the plaintiff is enjoying the interim order accordingly.
Item number 8, but before you accept this, item number 44.
Yes.
8. Milord, 8, I am the plaintiff. If you look.
I am the respondent, Milord.
I believe this matter will continue up to 3:30.
No, it will not taken today. 44, na?
44 is my prayer is this. Next Friday is also not to be taken.
I'm seeking for extension of time to file affidavit.
Item number 44 record karo. As per the prayer made by the counsel for the defendant.
For the plaintiff.
Plaintiff.
My review application is and I am asking for extension of time to file the affidavit in reply.
You are for the counsel for the applicant prays for time to file affidavit in opposition, affidavit in reply. Let affidavit reply be filed within a week after vacation. Appear on 14th. 14th.
Lord, may I file my opposition?
Keep it on the next.
Keep it on record today.
The affidavit in opposition be kept with the filed by the plaintiff be kept with the record. Yes. Item
Before
number
Mr.
8.
Post starts, my lord, I need to, my lord, make a little. Sorry, my lord.
You are raising the maintainability.
Yeah.
I'm against the interim relief, my lord. I'll show a little bit of. It is also according. Paid for. I never take days, my lord. So, my lord, I'll only take 10 minutes, not even 10 minutes, not even 10 minutes, not even 10 minutes. When I say, now, my lord, I showed that this is a, my lord, CS which has been filed in 2024.
Correct.
Now, my lord, kindly takes, my lord, the High Court Commercial Courts Practice Direction 2021, which was issued on 13th of October 2023.
हमने तो रखा हुआ है। आपका फर्स्ट बुक क्या है? वो बुक क्या है? वो बुक क्या है? And I have to work more, 2 hours extra to teach all of you.
Now, my lord, in this, lordship will find this practice directions came in, my lord, on 13th of October 2023. So, admittedly, prior to the suit being filed. Now, my lord, kindly comes to 4. Not like the earlier section 15, my lord, under the act, whereby, my lord, pending suits could have been transferred. Kindly takes 4. Then, my lord, kindly takes 1. Every suit, appeal, or proceeding pending before any civil court as per the Bengal Agra Assam
Where from
Act.
you are reading? Where from you are reading?
My lord, Rule 4.
Rule 4.
Yes. Which, my lord, the heading is Part 2, Identification and Transfer of Pending Commercial Disputes. Lordship has got it, my lord?
Rule 4, transfer and pending, yes.
Yes. My lord, kindly sees transfer of pending cases. Every suit, we are concerned about suit, pending before any civil court as per the Bengal, Agra and Assam Civil Courts Act 1887 or in the High Court, immediately before the date of issuance of the appropriate notification, that is this one, my lord, of the pecuniary value in terms of section 3(1) capital A of the Act, being a suit, the cause of action whereof is based and valuation of the relief of which is such that it would have been, if had been filed after the commencement of the Act within the jurisdiction of the Commercial Division or Commercial Appellate Division in the High Court or within the jurisdiction of the Commercial Courts or Commercial Appellate Courts at the district level, shall be transferred. So what was pending can be transferred.
Yes.
Now lordship takes 2, where the bar comes.
Yes.
The above provision for transfer shall not be applicable to suits, I'm not reading appeals and all, instituted before any civil court as per the Bengal, Agra, Assam Civil Courts Act 1887 or in the High Court in its ordinary original civil jurisdiction, as lordship is, after the date of issuance of appropriate notification of pecuniary value. So, my lord, after 13th of October 2023, this suit has been filed, which cannot be transferred. It has to be dismissed. Now, my lord, kindly comes to the section which, my lord, I had shown last day, to which, my lord, Commercial Courts Act kindly takes 2C. 2CI.
Yes.
My lord, kindly sees commercial dispute means a dispute arising out of ordinary transactions of merchants, bankers, financiers. So to this, although I am a banker, he has made a loan agreement with me. He gives an answer, my lord, that the suit is, my lord, with regard to a letter of understanding. Well, let us see, my lord, from his own documents, need not look into my anything. My lord, will kindly come to the document which is the letter of understanding in, my lord, the opposition in the opposition which I have filed. My lord, kindly comes to That starts at page 55.
Yes.
Now, my lord will kindly see who are the parties. The parties, my lord, is stated at page 56. Lordship has got it, my lord.
Yes.
57 at the top.
Yes.
And then, my lord, will find that, my lord, at 59, Lordship will find that, my lord, the agreement numbers are given. Lordship has got it, my lord.
Yes.
Now, my lord, kindly sees all these agreement numbers are, my lord, at the top. Before that reads the paragraph. May I read?
Agreement number?
Yes. My lord, just takes 59, the second paragraph. There's a box just over it.
Yes.
The obligers have availed financial facilities aggregating to 51 crores and odd from Kotak Mahindra Prime Limited under various sanction letters, loan agreements. Kindly will mark it.
Correct.
That in the above financial facilities, there are outstanding amounts due and payable by the borrower to Kotak, the various loan accounts having outstanding amount of 27 crores. So this is what is due and payable. Now, my lord, just below that, kindly takes, my lord, the second column. Lordship has got APAC numbers in the box, my lord.
Yes.
Those are all the agreement numbers, my lord. Kindly see CF 105888356. Lordship has got.
Yes.
So, my lord, it is not a stillborn baby without a mother. The agreements are there from which this letter of understanding has taken a birth. Now, my lord, therefore saying that I have come before the court, this is not a financial transaction which will fall under 2C1, is, my lord, something, my lord, which has no basis at all. Otherwise, there cannot be any letter of understanding at all. Now, my lord, kindly comes to page 61. Now, kindly sees, my lord, in the opposition, in page 61, third column, my lord, records the amount which has been paid to them. 51 crores and odd. Lordship has found, my lord.
Yes.
The next column shows, my lord, 27 crores and odd. Lordship has found, my lord.
Correct.
That's the due amount. Now, my lord, this is the due amount which, my lord, he has to pay back to me. This entire due amount is the amount which he has to pay back to me. Not, my lord, what he is trying to show before my lord. Now, my lord, kindly comes to, my lord, this next page. Please. In this, kindly lordship will mark in the box, which is, my lord, at 59. The first entity, that is, my lord, Mohan Motor Distributors Private Limited. Lordship has got at 59 in the box. That is under liquidation. Lordship will mark.
Yes, that is.
Now, that is under liquidation. Now, my lord, will also mark at page, my lord, 60. There is another name, my lord, which is in 03, the first column at page 60, which is Mohan Motor Udyog Private Limited. That's also under liquidation.
Yes.
But, my lord, the agreements which have culminated in the, my lord, letter of understanding is with regard to all these borrowers and their guarantors. So, even if 2 goes, the amount that is due from them will not go because there are guarantors to that agreement against whom I am proceeding.
As per the case of Mr. Bose, the amount has been segregated. So
There is no amount which is segregated. I will show, my lord. I'll show it. There is no amount segregated because in those agreements, the guarantor comes in. I'll proceed against the guarantor who is also a party here and who is also a party to the 13-2 notice. I made him a party consciously, which has not been shown. So therefore, my lord, the entire amount is due. Now, my lord, kindly sees, my lord, the fallacy with which, my lord, the draft has been made. Now, my lord, kindly takes, my lord, the next page, which is lordship's page, my lord, is page, my lord, 62.
Yes.
Lordship will find paragraph 6 there. Now, my lord, how does this baby is born from the mother of the agreements? It's stated there. After signing of this letter of understanding of statutory notice issued through letter dated 18/7/2019, this was the first 13-2. There are 3 13-2s. Shall be kept in abeyance till the pendency of this present only, for the property is mentioned in Schedule 2 only, not anything else. Schedule 2. It is needless to mention that on the failure of the settlement, KMPL shall be at liberty to proceed all allegations which either adjourn or kept in abeyance.
So, my lord, this was the understanding. Only that which schedule 2 I will not proceed with.
Yes.
Because, my lord, obviously, I am not settling, my lord, in this letter of understanding for 27 crores for an odd of 12.5 crores, which I'll get from these lease rentals.
Okay.
Now, my lord, kindly comes to the next page. Kindly takes, my lord, page 63, paragraph 10. Very important. What has been, who are exempted? The guarantor numbers 1 and 3 have approached KMPL, that is my clients, and requested KMPL to provide consent to lease out immovable property, more particularly mentioned in Schedule 2. Only that property. Annexed head 2 to 1 Narbheram Leasing Company Private Limited for a period of 99 months and further agreed to provide consent to appropriate the monthly rent, maintenance, facilities, charges, receivables, part of the outstanding amounts to KMPL under the financial facility. So, my lord, part of this amount which is due, that is 27 crores and all, I will, my lord, recover from the lease rental which I have agreed to, my lord, give this property for. Now, my lord, kindly takes the next paragraph 11. KMPL, my client, has agreed and provided its consent to the guarantor numbers 1 and 3 only, lordship will mark, for leasing immovable property more particularly mentioned in Schedule 2 to 1 Narbheram Finance for a period of 8.3 years, 99 months term, subject to the terms and conditions in the consent. Now, my lord, kindly takes apropos this, the next paragraph, that's, my lord, 64, my lord, after the Roman 3, the lease, the lessee Narbheram, what I'll get, my lord, what amount of money I'll get. The lessee Narbheram Leasing Company shall pay an amount of 80 lakhs upfront. That's, my lord, a fixed deposit, my lord, a deposit that they'll make interest-free, non-refundable. 80 lakhs I'll get.
Who are you?
I am, my lord, the bank. I am the respondent.
Kotak Mahindra.
Yes. NBFC. Very well, my lord. Finance company. Now, my lord, I will get 80 lakhs as my recovery's first, my lord, procedure. Then, my lord, takes the bullet point 2. The initial monthly less rent and maintenance facility charges from the 1st to the 36th month is 10 lakhs 79 per month. This I've got. Now, my lord, next bullet point. The monthly lease rent and maintenance facility charges for the remaining 37 to 72nd month would be 12 lakh 47,000. This also, my lord, part of it I have got. Then, my lord, the third, kindly takes the third, my lord, option, which is, my lord, the monthly lease rental facility for remaining commencement of 63 months, 99 months, 73 to 99 months is 14 lakhs 14,000. Now, my lord, if your lordship adds up all of these till the 99th month, it would come to roughly, my lord, 12 lakhs 19,000 and 12 crores 19,000 and odd. Whereas my claim is 27 crores. Now, my lord, as on today, I have recovered, my lord, around, my lord, 24 crores and 24.
27 crores, 54
Sorry.
lakhs.
So, therefore, my lord, around 19 crores.
7.5 crores.
After this. Oh, my lord, I have received, I should receive from there only 12 crores 19 lakhs. I have received 7 crores 54 lakhs 60,000 till date. I will give the details. I have no issues, my lord. So, out of 12 crores 18, not 27 crores from the lease rentals, I have got 7 crores 54 lakhs and odd. This is till September. Now, my lord, kindly sees, my lord, what happens after that. Kindly takes,
Received
my lord,
only?
10. My lord?
Received only?
Sure, yes. 7 crores 54 lakhs 60,000 080 received till September 2025, which includes the security deposits of 80 lakhs. So, the default
Yes.
So, there is a default already. There is a default already. Now, my lord, kindly sees this letter of understanding also records the mechanism how to, my lord, do things after the default takes place. Now, my lord, kindly sees the next page, which is, my lord, Roman, my lord, 207. My lord, here, my lord, it would be Roman 6. Roman 6 at page 65.
Yes.
Sees what is the default mechanism as far as these two properties are concerned. Kindly sees that in the event of any default in the routing of the receivables, lease rentals in any month,
shall result in automatic termination of this conditional permission, as well as the lease agreement of the said property so executed by KMPL without any prejudice whatsoever, shall have the absolute right and interest to take vacant physical possession of the property specified in Schedule 1 and enforce his security rights against the borrowers and the guarantors under provisions of Surface Act 2002. So, my lord, if there is a default with regard to these lease rentals and those two properties in the schedule, my lord, I can automatically terminate and issue, my lord, a notice under 13(2). Automatically. Now, my lord, kindly takes the next clause, which is, my lord, kindly sees, my lord, clause, my lord, which is, my lord, at page 67, clause 14.
Yes.
67, clause 14. We, the borrowers and the guarantors, that is them, both the categories, hereby agree and confirm that we shall continue to be liable to make payments of unpaid outstanding amounts under the financial facilities, which includes principal, applicable interest, penalties, and such other charges as mentioned, and KMPL shall be free to pursue all available legal remedies, including those available under the provisions of Surface Act. So, therefore, my lord, for the 27 crores, I can proceed against them apart from this also. There is nothing recorded here that, my lord, by paying 12 crores, 19 lakhs, which he has also not paid, my lord, his entire amount of 27 crores is absolved. I am giving it up. That is nowhere there. This impression being created, my lord, that's not recorded in the agreement itself. Those agreement of the financial, my lord, payments which are due under the facilities, I am entitled to recover by filing surfacey proceedings. Now, my lord, kindly sees most interesting part, Schedule 2. And then I'll show the prayer, how it has been couched, which lordship had not allowed, my lord. My lord, kindly comes to page 70. What is Schedule 2? Schedule 2 consists of two properties only. One, my lord, is a property of 1150 square feet, which is, my lord, office block number 1, ground floor, such and such at Shakespeare Shorumi. Lordship has got it, my lord. Premises number 55 and 55/1. And the next property lordship will take in Schedule 2, page 71. This is a 17 katas land lying, my lord, in Mouja, Dhalenda. Dag number lordship will kindly mark, my lord, is 50. So this letter of understanding does not talk about any other property. Now, my lord, straight away let us come to the praise that they have made, which lordship had not allowed. Kindly takes, my lord, volume 1. I am shocked to see what is going on, my lord. My lord, kindly takes the prayer, page 27. Prayer C. Injunction directing the respondent number 1 to make over to the petitioner number 1 the title deeds in respect of property or Dhalenda PS number. Kindly mark the dark numbers, my lord. 65, 66, 66, 65, 66, 67. This is not part of the letter of understanding even. And this was moved ex parte without a notice. So this is the first time I am addressing my lord. Last time, my lord, I was told that why these submissions are made, opportunity is gone. How? They tried to move it ex parte without serving notice, which was refused by my lord. First time I took the point before the Honorable High Court, Division Bench, which is sent back to this Honorable Court, remanded back the matter. So lordship is hearing it for the first time. A prayer of a property not part of the agreement itself.
Yes. Next.
Now, my lord, kindly sees the 13(2) notice. How can lordship stop, my lord, a proceeding before the surfacey? I am not aware of, and that too in a proceeding not maintainable in this, my lord, jurisdiction. Kindly takes the 13(2) notice, which is, my lord, is at page. Next. Give me one moment, my lord. কোনটা দেখছেন?
75.
75. Grateful. Yes. 5/3/2024. Now, my lord, kindly sees whom it is addressed to. Everybody. The borrowers as well as the guarantors. And the obligation is coextensive.
Yes.
So the segregation cannot be done. Now, my lord, kindly comes to, my lord, page 77. My total dues now, my lord, as on date is 50 crores and odd with interest in view of the failure. And lordship, this is going to be adjudicated by the surface tribunal, not before my lord. Now, my lord, kindly sees, my lord, the properties that we have, my lord, shown here. Kindly comes to page 83. I have not dealt with properties which are part of the letter of understanding. I'm sure this was shown to my lord, upon which lordship refused the interim injunction. All that piece and parcel of land at, my lord, dag number lordship will mark 65.
Yes.
Second one is also dag number 65. Third one is, my lord, dag number 66. And fourth is dag number 67. These are not part of the, my lord, letter of understanding. And even under that also he has, my lord, failed now, defaulted, we find. We'll issue a notice upon that, my lord, also. He has a remedy for that before the tribunal also.
Yes.
Now, my lord, I want to show a judgment where it is being held now categorically. Jurisdiction. That, my lord, if the court doesn't have jurisdiction otherwise under the law, my lord, the court will not entertain even. And this is the first time I'm coming up before my lord, because the earlier instance was ex parte. My lord, this is the judgment reported in, my lord, from Manu Patro, Manu SC/1004 2022. And, my lord, the SCC citation is also there.
No SC.
2022 10 SCC page 1. This is the famous.
Which one?
Patil automation.
Patil automation.
Yes, but I want to rely on one portion of that judgment. Kindly comes to, my lord. That's just above paragraph 68. Kindly sees the observations made, so that the courts are guided in the proper path, my lord.
Yes.
On a consideration of the scheme of the orders 6, 5, and 7 of the Code of Civil Procedure, we arrive at the following conclusions. So after the observations, the conclusion is also, my lord, stated. Now, my lord, I am showing from A itself. A suit is commenced by presentation of a plaint. The date of presentation in terms of section 3(2) of the Limitation Act is the date of presentation for the purpose of the said act. By virtue of order 6, rule 1(3), institution of plaint, however, is complete only when the plaint is in the conformity with the requirement of order 7, order 6 and order 7. Then what kindly leaves 5, comes to C. Order 7, Rule 11 does not provide that the court is to discharge its duty of rejecting the plaint only on an application. So this was said, my lord, on the last day, that there is no application, nothing. I have got a pleading. I'll show. Not required, because this is question of law. Order 7, Rule 11 does not provide that the court is to discharge its duty of rejecting the plaint only on an application. Order 7, Rule 11 is in fact silent about any such requirement. Section does not, or the provision does not require an application. Since summon is to be issued in a duly instituted suit in a case where the plaint is barred under Order 7, Rule 11D, the stage begins at the time when the court can reject the plaint. So the moment I come and, my lord, oppose and say, that's the time. Reject the plaint under Order 7, Rule 11. No doubt, it would take a clear case where the court is satisfied. I have to satisfy, my lord. Then, my lord, the court has to hear the plaintiff before it invokes its powers, besides giving reasons under Order 7, Rule 12. In a clear case where allegations in the suit it is found that the suit is barred by any law, as in this case, my lord, as would be the case where the plaintiff in a suit under the Act does not plead circumstances to take his case out of the requirement of Section 12A. Here, my lord, that stage has even not come because, my lord, he has not even presented in the correct division. The plaint should be rejected without issuing summons. Undoubtedly, on issuing summons, it will be always open to the defendant to make an application as well as under Order 7 rule. So, my lord, here summons have not been issued. So, I don't need to file an application. Summons were issued, I had to come with an application. In other words, the power of Order 7 Rule 11 is available to the court to be exercised suo motu. So, therefore, my lord, I say, Supreme Court therefore, my lord, I say that when on the face of it, I can show from his own documents that, my lord, this is a transaction which is, my lord, a baby of the original agreements. And, my lord, it is against the guarantors, coextensive with the, my lord, borrowers. Even if two have gone into liquidation, that has been, my lord, secured by the guarantors in those agreements. He has defaulted apropos, my lord, with regard to the rest of the amount on the date of signing itself. And, my lord, he has defaulted now in terms of the agreement also, under letter of undertaking. Letter of undertaking records two properties which I have not gone against. I have gone against the other properties. So, my lord, this court has no jurisdiction at all since I have issued the 13-2. This is, my lord, just, my lord, a bend upon theory where, my lord, is trying to curtail my proceedings before the, my lord, tribunal or the DRT by, my lord, getting an order from my lord of an injunction order over a property which is not even the subject matter of the undertaking also. And, my lord, on the threshold, my lord, in view of the practice guidelines, my lord, it has to be rejected, my lord. And this judgment clearly supports it. I don't need to file an application. Those are my submissions.
My lord, sorry. My lord,
কি বলতে দাও বলতে দাও
So, my lord, when do I have to come?
I'm sorry, my lord, I had to take a little more time.
No.
Counsel for the defendant had concluded his argument in reply to the counsel for due to paucity of time, counsel for the defendant could not reply to the submission made by the counsel for the defendant. According case adjourned, let the matter appear. कब है कितना बजे कौन सा डेट पहले कोई नहीं है कब है फर्स्ट डेट कब अवेलेबल है
Lordship has gone into December or January, my lord.
That's why I'm adjusting.
My lord, if your lordship stop fixing matters, your lordship will be able to take all matters. Because, of course.
I have applied that, but what is happening? So one matter continuing for the days together.
That again,
other the beginners are not able to
exactly,
do their matters.
Exactly. That is even.
Or your lordship can fix matters after 2 o'clock.
I have not fixed, but I find that these beginners.
The
are
list
not
cannot
able
be
to
taken.
move their matters.
Correct.
No, lordship will fix a date and time, my lord, any day.
नहीं पहले नवंबर में कौन सा कोई डेट नहीं है कब है वही तो बोला कौन सा डेट है 23 उससे पहले कोई नहीं है सब पूजा छुट्टियां भूल जाएगा 13 नवंबर 11:30 है matter fixed on 13th November
6th October
at 11:30
13 November at 3 p.m.
13 November 11:30
11:30. Grateful, deep love.
May I have your lordship's kind leave to mention item number 62, praying for an extension of the interim order.
Non-commercial?
The non-commercial list, my lord. And my lord, 2 of my pleadings have to be filed as well.
52?
62, my lord.
62.
Cost of Junjunwala.
Interim order is there?
Interim order is there, my lord. This was the last interim order passed by your lordship.
And my lord, I want to file my affidavit in reply in GA1 and my affidavit in opposition in GA2. All served on the other side.
Plaintiff. Who is
I'm for the plaintiff,
defendant?
my lord. My lord, Mr. Upadhyay.
Counsel for the plaintiff has filed affidavit in opposition in connection with GA2.
Opposition in GA2, my lord.
Affidavit in reply in connection with GA1 of 2024 after serving the copy to the learned counsel for the defendant. Let the same be kept with the record.
Lordship,
Counsel for the plaintiff prays for extension of the interim order.
Lordship, only I was since the pleadings are completed, Lordship. Any day may be fixed, Lordship.
Reply you
After
will
the
file.
Lordship, that we will file it. That is not the
Counsel for the
we have a
defendant prays
vacation.
for time to file affidavit in reply to the affidavit in opposition in connection
They
with
have filed it
GA2 of
after 2 months, Lordship. So,
Let affidavit in opposition be filed within a week after puja vacation.
Lordship, any day, Lordship, we fix it.
Interim order is extended till 21st of November 2025 or until further order, whichever is earlier. Let the matter appear on 21st November.
Any time may be fixed, Lordship.
Time then December. That's what I'm telling.
Any,
So
because
what are the parts
they have
that
been
I am adjusting so that matter can be disposed?
because the interim order, what they have been extending from last 1 year, Lordship. Any day, Lordship.
December you come, then I.
So again, it will go to January.
No, December I am fixing.
We'll come back in November.
Today we'll let's fix it any day, Lordship,
December
because only
date.
one day, Friday is being taken up.
Date, time, 23rd December.
November,
23rd December at 3 p.m. Interim order is extended till 23rd December or until further order, whichever is that.
My lord, may I have your lordship's kindly respect of item 35. It was called, however, I appear on
Which
time.
matter? Non-commercial?
35 non-commercial to your lordship.
30?
35.
Ah.
My lord, just bring that, any day convenient to your lordship.
Already passed an order.
My lord, it's been kept for December.
Ah.
My lord, kindly keeps it on.
You not appeared yes, any mentioning?
My lordship, may I?
But I am on the way, but your lordship has called and dismissed. Your lordship kindly fix the
Which one?
Lordship 25, item number 25.
Ah.
Lordship kindly fix the after 2 weeks of the opening of the vacancy.
25?
25.
Non-commercial?
Not commercial.
Dismiss for default. You are not appeared.
Lordship, please.
25 का order कौन लिया? उसको मत तो करो बोलो, not today करो.
Your lordship, may I have your kind leave to mention?
उसको हटा दो, मत करो बोलो.
I have a kind leave to mention, your lordship, item number 53, non-commercial, your lordship. It's extension for interim order, your lordship. The interim order is expiring today. This is the last order.
Which for the other side?
Lordship, we should notice, your lordship.
Record an order.
Yes.
Counsel for the plaintiff prays for extension of interim order. Interim order is extended. Let the matter remain in the list. Extended till 20th November 2025 or until further order, whichever is earlier. Let the matter remain in the list.
Grateful, your lordship.
My lord, just one request. Kindly for item 35 records the fact that none of the parties have been present. It's been recorded.
Correct.
From code 30, your lordship, you just missed it by 2 minutes, your lordship. Kindly consider.
That is the problem. You persons are not on once the courtesy order is
never
passed.
happened. I've always been there. My apologies.
Which
for
matter?
My lord, item 35.
35 not today कर दो.
May I leave item number 59, my lord, which is substitution application for expunging the name of the one of the defendant, my lord.
Item number
59, my lord.
Ah. So what happened?
My lord, it's an application for expunging the name of the defendant, my lord, whose legally is already on record, my lord. My lord, we have filed a supplementary affidavit, my lord, indicating the manner of
What's the urgency? Let the matter when call it will be taken up. Today the time is over.
My lord, the joint property, my lord, till the name, my lord, there some difficulty will be facing by the other person, my lord.
For what?
My lord, some
mother expired. Court allowed the substitution. Now, before this amendments could be carried out in the records, my lord, her younger son has also expired. Last week, when this matter was taken up, your lordship desire was to see that order of substitution of the mother. So I have brought that order. Your lordship will only consider it and only give one line order. So department will carry out.
What?
So for us expunging the name, my lord. Only the one thing. 59, my lord.
काम करे matter है ना?
59.
59 है ना? उसको next Friday ऊपर कर दो.
अच्छा ठीक तय तापर देखो
to only mention my item 40 of your lordship's non-commercial list, my lord, an application for correction of a judgment and order, my lord. It'll only take your lordship 1 minute, my lord. I've
40?
indicated item 40, my lord. I've already indicated, my lord, in the application, my lord,
What
for correction.
judgment? What
My
correction?
lord, the judgment and order, my lord, is dated, my lord, of 24th January 2024, my lord. In Annexure D, my lord, I've given, my lord, a copy of your lordship's judgment and decree, my lord, indicating in reading, my lord, the corrections.
What correction?
Yes.
Where is that?
Item 40. Item 40 to check with it.
Serial number? Where is the page number?
My lord, kindly takes, my lord, the last page, my lord, it's not number, my lord, page 120. My lord, 129. Second last page, my lord. My lord, would kindly see, my lord, it's indicated, my lord, in red ink, my lord, and the page before that, my lord, as well. 128 and my lord, 129.
So what you want?
My lord, that correction, my lord, of the judgment.
Red wing flat number 16.
Yes, my lord. It's in red underline, my lord.
And at park being flat. No. In view of the above, the court finds the plaintiff is entitled to get the decree for recovery of the vacant and peaceful possession of the flat being flat number 16.
Yes, my lord. That is there in red underline, my lord.
But where is the schedule?
Yes, my lord. My lord, I've particularized, my lord, the errors, my lord.
Where is the schedule?
My lord, kindly
in the plaint?
Yes, my lord. Kindly takes, my lord, the plaint. The plaint, my lord, starts from page 10, my lord, of the application, my lord.
Schedule, where is the schedule?
Yes, my lord.
Schedule promises. Kindly come that.
Yes, my lord. Kindly takes, my lord, the prayers, page 17A typed copy. My lord. Decree, my lord. That's the first prayer, my lord. And my lord, the schedule, my lord, is at page 21, typed copy at page 21A.
Correct.
Yes, my lord. That's flat number 16, my lord.
In the second floor of the park mission, premises number 33 and 34.
Yes, my
And
lord. Apropos that, my lord, takes page 128, my lord. Para 29, my lord. And also, my lord, the other corrections are, my lord, at the next page.
Here has been corrected, I think, earlier.
Yes, my lord. I'm grateful, my lord. The earlier order, my lord, had passed, my lord. The department has refused to carry it out, my lord.
What?
Yes, my lord. I do not know, my lord. I've taken instructions. My lord's order, I've also annexed, my lord, to the application, my lord. That order, your lordship's order, my lord, that's at page 112.
The plaintiff has filed the present application, being GA4 of 2025, praying for correction in the judgment dated 24th of January 2024, and submits that in paragraph 29 of page 15, paragraph 29 of the judgment in the correction in the judgment dated 24 January 2024, and submits that in paragraph 29, line number 3, the sentence is to be added, inward comma, sentence is to be added after the word being flat, then inward comma, number 16 in the second floor at Park Mansion being premises, inward comma close. After the word being flat and before the word numbers 33. Before the words number 33. At paragraph and at line number 6, 7, 8, 9, after the word flat and before the word number 33 shall be added as same, number 16 in the second floor, at Park Mansion being premises. Okay? And in line number kitna number? 1, 2, 3, 4. And in paragraph 11, after the word Park Street, the word Calcutta to be added. Similarly, in paragraph 13, 30 in line number, line number 3.
Yes, my lord.
In line number 3, before the word flat, and after the word flat, and before the word numbers 33 shall be added, the following words be added. Number 16 in the second floor at Park Mansion being premises. Okay. In the same paragraph, at line number 8, the word special officer shall be read as special referee. Special referee. And paragraph 10, na?
Yes, my lord. Paragraph
Line number
10
10.
10 and 11, my lord. Same.
11. 10 and 11. In paragraph 10 and 11 also, the word special officer shall be read as special referee. And in paragraph 31, the date, paragraph 31, first line, the date shall be read as 5th November 2003 instead of 5th November 2023.
But let us possibly mention paragraph numbers 10 and 11, my lord. Line number,
line
my lord,
number,
line.
Fifth,
Line
2003 instead of 5th November 2023. और ऊपर जो भी बोला है सब line numbers होगा.
10 and 11.
Paragraph 30, line number 3, 4, 5, 6, 7, 8, 10 and 11.
And my lord, I'll be seeking, my lord, prayer in terms of prayer B, my lord, of the master summons, my lord. The drawing up of the decree, my lord, in terms of the corrections, my lord.
The department is directed to make necessary correction in terms of the above order. Above order, full stop. And after the correction is made, the department is directed to draw the decree as early as possible.
I'm very grateful, deeply.
CN GS 4 of 2025 we disposed of.
415 today's matter, fixed to 415 today fixed matter. This is that matter, my lord, where there's a dispute regarding Shobha and Shobha. Now, that's a probate matter. We have put in the 50,000 court fee. The last day when this matter was taken up, your lordship's desire was to see the original records, my lord.
Your record aaya kya? Yes. You are appearing for?
I am appearing for the executor. Now, this issue has been raised by the caveatrix. They made an application. My lord was hearing their application. The only difficulty which I am facing is that the difficulty which I am facing, I cannot get the probate, my lord. I have put in the 50,000, but I can't get the probate since the records are before, my lord.
Record has come just 2 days before.
2 days before, because since it was sent, it was arranged and it was sent. So,
what is the record? Is it Shobha or Sova?
I have not seen.
So can I dispose of herein now?
No, but their presence is required.
If they are benefited, they will win. No.
No. Because I have checked.
If you want, I will see the record and dispose of herein now, and I will send you.
Kindly see it, my lord.
Can record hai, Baba?
Today or tomorrow, this will happen. Shobha.
नहीं आया, छोड़ो.
English name is Sova. According to her own affidavit, is SOV. Sova. Now they are coming is Shobha. SOBH. BH. They wanted to invoke 152. So I have checked the law.
Caveat file
Caveat and the affidavit in support of the caveat.
अरे ये नहीं, ये रहने दो. Caveat उसमें है ना.
Caveat और affidavit in support of the
caveat. If you have any difficulty, you ask me. If you have any difficulty, correction ka, you will do, na? Yes, Shobha. SOBH. No, Hindi mein Shobha.
Shobha, that's Hindi. Shobha.
What is the contention?
My contention is they wanted my lord to invoke 152. I have checked up the law. 152 can be invoked only when there's an error from my lord's part.
Correct.
In pronouncing the judgment.
Correct.
Now they have given the name as Shobha. They have continued with it. So 152 will not apply. So if they want any correction, they have to go before the appeal court, not before my lord. If it is error from my lord's part, they can certainly come under 152. But if it is not, they have to go before the appeal court. Because once my lord has pronounces the judgment, my lord's.
Yes. Let they come. What can be?
Let the records go, my lord.
No, how it can be?
Okay,
come. But
next week,
they record an order. Item number
12.
12. The counsel for the plaintiff submits that as this court has called for the record of TS number 20 of 2016, due to which the department is not in a position to
issue the probate.
Complete the decree.
Complete the decree.
Complete the decree and issue probate. Issue probate in terms of the decree passed by this, in terms of the judgment passed by this court. Accordingly, let the record of TS 20 of 2016 be sent to the department with the direction to place the said record before this court. Before this court on on 7th of November 2024.
Only
on
one.
Or before 7th, on 7th November 2024.
Only one thing, my lord has asked the officers to place item 59 on the next week, fairly little at the top. If it can be taken up before that, because on the last
Before
day,
only that is the last day work.
last working day. That's why.
I don't think the court will sit.
No, probably my lord sits. I know. My lord will sit till 3:30.